Halsey, David, did you guys receive my exhibits okay this morning? Should have come in from my paralegal, Don.
We got it.
Yeah, we did receive it.
We got an email.
You got them? Okay. Have you been able to get them to your client so they can use them during examination?
We just handed it to him.
All right. Very good.
Same question to you. Did you hand to your client the exhibits that we filed yesterday?
Yes.
Thank you.
Did you guys see the court just sent a message that we're gonna delay till 10:15?
Yes, thanks.
Okay. That just came in, Jill?
Yeah, it's in the chat. It just popped up.
Okay. All right. Good.
Good morning, everyone. While we're waiting for the judge to come in at 10:15, can I just verify? I have everybody's name except for, I'm not sure, it says HKNAPP. Hi, sir. Good morning.
Morning.
Okay.
Mine is Halsey, Halsey is the first name. Knapp, Knapp. I'm with the Crevlin Horst Law Firm. And we represent defendant Carter and Associates Enterprises, Inc. I have with me my colleague, who's also here in the conference room with me. I don't expect her to speak today. Her name is Sada, S-A-D-A, Bebe, B-A-B-Y.
Okay. Thank you for that. I appreciate it.
That's right. And you notice also there is a screen that shows guest. That's a separate conference room here in our firm. And there's two gentlemen in there. Robert Peterson, goes by the name of Bob, I believe, and Scott Stringer, both of our client Carter and Associates.
Okay. The second name, Scott Stringer.
S-T-R-I-N-G-E-R.
Making sure. Thank you. I appreciate that.
You're very welcome, Ms. Brown. Which print is it?
I'll send it to the color. Good morning. Good morning.
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 Good morning.
Good, great. All right.
Morning, Judge.
Morning. Good to see you.
Good to see you.
Well, let's start with the motion to dismiss. That was the first motion filed. So. That's you?
Yes, Your Honor. This is Jill Dunn. I am co-counsel with Mr. Knapp and his firm for the defendant, Carter and Associates Enterprises, and we've moved to dismiss all of the claims that plaintiffs have asserted against Carter. I'm sure Your Honor is familiar with the factual background of this, so I won't delve into too much detail, but at a very high level, this stems from a transaction related to what we call the Turner Field project, the old location of Turner Field. In 2014, Carter, which is a national real estate investment and development company that's headquartered here in Atlanta, secured an exclusivity agreement with Georgia State University Foundation to form a partnership to acquire and redevelop that piece of property. Long story short, it's an 83-acre mixed-use project. It's going to include the development of 35 acres into a mixed-use neighborhood. It's going to include corporate office uses, multifamily apartments, retail, student apartments. And since closing in January of 2017, there's already been $510 million in investment, either constructed or planned within the development or in the surrounding area. Now, in connection with the Turner Field project, Carter selected co-defendant Oakwood Development Group, who I'll call Oakwood throughout the day, as its minority development partner. And Oakwood is a female minority-owned firm based in Atlanta, and it's owned by co-defendant Kelly King, who I think we'll hear from later today as well. So fast forward 4 years after the closing of the Turner Field project, plaintiffs Mr. Parks and his company, which is BPJ Enterprises, have come forward and alleged that BPJ has held a membership interest in Oakwood since the time the company was formed in 2014. And as a result, they filed this lawsuit and claimed that they are entitled to a share of Oakwood's proceeds from the Turner Field project and other development projects that aren't related to Carter at all. We view this as essentially an internal dispute, frankly, between Oakwood and Mr. Parks and his company. Carter hasn't ever had any membership interest in Oakwood. It's not involved in the internal affairs of the company, the operation of the company, anything of that nature. Nevertheless, Carter finds itself now in this lawsuit with Ms. King and Oakwood. And plaintiffs have sought an injunction, accounting, various other causes of action against Carter. And we don't think that there's grounds for any of it. And I'll go through, we argue all this in our motion. I don't want to belabor it, but, in terms of the aiding and abetting fiduciary duty and the tortious interference claims, those claims, in general, plaintiffs have alleged that Carter aided and abetted Ms. King somehow in the breach of certain fiduciary duties that she owed to the plaintiffs. And they claim that Carter has tortiously interfered with certain business relationships of the plaintiffs. Now, in Carter's initial motion to dismiss, we argued that plaintiffs were not members of Oakwood, period. And therefore, these claims fail because plaintiffs didn't have any basis and don't have any basis for pursuing them. In response, plaintiffs filed an amended complaint, which you've probably seen, which now attaches what plaintiffs claim to be a signed signature page of an operating agreement that plaintiffs argue shows that Mr. Parks is in fact a member of Oakwood. I don't want to get confused by this because it's our position that set that aside, regardless of the existence of this signature page that's appeared, it doesn't matter. In terms of the validity of these claims, they still fail. The allegations that form the basis of the fiduciary duty and tortious interference claims, contrary to what plaintiffs argues, they're not based on the intracorporate duties owed by one member of Oakwood to another. They're based, if you look at them, on really Ms. King's conduct in connection with Oakwood's overall role in the Turner Field project. Because of that, Carter is certainly not a stranger to that underlying project and that entire business relationship. Now, plaintiffs argue that the claims against Carter, arise from these intracorporate relationships and intracorporate duties owed by Ms. King under the Oakwood operating agreement. So plaintiffs argue the stranger doctrine doesn't apply here because Carter is a stranger, in fact, to the Oakwood relationship. But it's our position that under the law, and if you look at the actual nature of the claims, they really are founded on the project itself and Oakwood's conduct and Ms. King's conduct in connection with the project. And under Georgia case law, liability for aiding and abetting a breach of fiduciary duty requires that the defendant be a stranger to the contract at issue and the business relationship that gives rise to the contract. So it's our position that under this concept, under the law of what's called an interwoven contractual agreement, which means that a party that has any economic interest or standing to benefit from a business relationship cannot be a stranger to any underlying contract or that business relationship in general. So accordingly, it's our position that even if that these claims fail because Carter is clearly not a stranger to the underlying business relationship here. Even if plaintiff's claims are deemed to stem from duties that arise under the Oakwood operating agreement, as plaintiff posits, again, Carter was in a position by virtue of its involvement in the project to benefit from this underlying business relationship. So Carter can't be a stranger to that relationship. In terms of the plaintiff's unjust enrichment claim, that's an equitable claim. It fails where there is a contract or where there's an adequate remedy at law. And here, according just on the face of the complaint itself, the services that plaintiffs allege that they contributed to the Turner Field project were made through Oakwood. And the complaint makes clear in various places, paragraph 69, for example, paragraph 76, that all of these relationships are governed by contracts. Plaintiff's relationship with Oakwood, Oakwood's relationship with Carter, all of the transactions related to the Turner Field project closing itself. It also, under Georgia law, does not matter that those contractual relationships are not directly between Carter and the plaintiffs. The fact that there are existing contracts at issue between plaintiffs and third parties bars the claim as well. In addition, which we'll talk more about later today as well, plaintiffs have an adequate remedy at law here. That's kind of the overarching theme of the case, is that even if what plaintiffs say is true, unjust enrichment is an equitable remedy that is only available where there is not an adequate remedy at law. Now here, it's our position that monetary damages are sufficient here. Even if plaintiffs were to prevail, their damages are money. Their damages are, what they claim they should have received in the form of money from Oakwood's involvement in this project and from plaintiffs' alleged membership in Oakwood. So it's our position that the unjust enrichment claim fails for these reasons. Quantum merit, plaintiffs have also asserted a quantum merit claim against Carter based on plaintiffs providing, quote, services to Carter for which plaintiff claims that he expected to be compensated. Setting aside that, there really aren't any defined services in the complaint, any services that plaintiffs may have performed under plaintiff's theory that he's a member of Oakwood, those services would have been performed on behalf of Oakwood, not plaintiffs in his individual capacity or his entity. So plaintiff's claim really should be asserted against Oakwood to the extent that he has one, not Carter. In addition, for the same reasons that discussed a few minutes ago about unjust enrichment, the existence of contractual relationships also bar the quantum merit claim as well. So it's Carter's position that that claim is not viable against Carter and should be dismissed. Plaintiff has also asserted RICO claims here. You know, it's our position that this is pretty far-reaching, and plaintiffs allege that the predicate offenses in this case are, number one, a theft by taking and theft by deception under 1682 or 1683, and then mail and wire fraud in violation of USC 1341 and 1342. As an initial matter, we would argue that if the court is inclined to let these claims go forward, that plaintiff be required to amend the complaint to plead these claims with the requisite level of detail that is required. They're not pled with particularity. The allegations are very general. So we would argue that if the court is not going to dismiss the claims outright, that plaintiffs amend the pleading to state the claims with the required level of specificity. However, it's our position that the claims fail for a few reasons. First is that plaintiffs haven't alleged what property was purportedly stolen. Now, I understand that they claim that the funds, this $300,000 that they provided to Oakwood as a capital contribution toward the project, constitute the property. But the complaint doesn't allege any facts that these funds ever belonged to plaintiffs. Now, plaintiffs allege that a third party who was purportedly indebted to Mr. Parks made the investment directly into Oakwood at Mr. Parks's direction. But plaintiff didn't make any investment of his own funds into Oakwood. And those funds, despite the fact that they might have been allegedly owed to Mr. Parks, can't be construed as plaintiff's property. That's not how the law treats money. If it was money that was on deposit in a bank or in a financial institution, that has been held to constitute intangible personal property, but that's not the situation here. These funds weren't held on deposit. These were funds that were allegedly owed to Mr. Parks and were sort of informally funneled into Oakwood, ostensibly at his request and on his behalf. So it's our argument that that's not sufficient to allege that the plaintiff's property was stolen to support a RICO claim. The second issue is that we allege that plaintiffs have failed to state the requisite elements of mail or wire fraud here. And Your Honor knows that that requires that a person or an entity, Carter in this case, intentionally participate in a scheme to defraud another of money or property and use the mails or wires in furtherance of that scheme. And in connection with that, the plaintiffs would have to allege that the use of the United States mail or wires played an integral part, not just an incidental or tangential role in the fraudulent scheme. You know, it's here, the complaint really, as I mentioned, is devoid of any specific factual allegations that use of the mail or wire was any sort of integral part of this alleged scheme that the defendants were involved in. Plaintiffs state that defendants used mail and or wire communications for the purpose of executing an allegedly fraudulent scheme, which is sort of boilerplate general language that's included in these allegations without any specificity about when, where, how, any of those details. And plaintiffs also allege that Oakwood's capital contribution was made by wire, again, by a third party, though, not by plaintiffs. But again, plaintiffs haven't made any allegations that would support a finding that the use of this one wire transaction was somehow integral to the scheme. In fact, it was plaintiff's investment of his own money that was that involved the use of the wire here, no act by defendants. So it's our position that the claim should be dismissed. As a result, the conspiracy claim that is attached to the RICO claim should be dismissed as well, or again, as I said, alternatively, repled with additional specificity. The plaintiff has also asserted an accounting claim against Carter. Again, as with unjust enrichment and quantum merit, there's an adequate remedy at law here. And additionally, it's Oakwood that has an interest in the Turner Field project. It's not plaintiffs individually. Now, plaintiffs don't allege that any funds are being withheld from Oakwood. So to the extent that they do have an accounting claim, I think that claim would be against Oakwood. They would need to see what Oakwood's finances look like, not Carter's, not, Carter as an entire entity. I don't think they have a right to that broad of a scope of relief here. And so the accounting claim should be dismissed as well. And finally, the plaintiffs have asserted punitive damages and attorney's fees claims, as we allege in our brief, with no underlying torts to support those claims. Those claims should fail as well.
And that's a wrap.
That's a wrap, Your Honor.
All right, let me hear. First of all, I'm sorry, I should have done this at the outset. Let's get appearances on the record, please.
Jill Dunn, as I said, on behalf of Carter and Associates Enterprises, Inc.
Good morning, Judge Dover. Good to see you. Vaughn DuBose on behalf of the plaintiffs.
Your Honor, Halsey Knapp and my colleague Seda Bebe on behalf of Carter and Associates Enterprises, Inc.
Your Honor, Megan Mitchell and David Marmons of Arnold Walden Gregory are here on behalf of Kelly King, Oakwood Development Group, LLC, and CL, LLC.
We have everyone?
Your Honor, we have, I have with me in the conference room I am with Scott Taylor. Would you bring him into view? Here with me, president of the company. In a separate conference room, which on my screen is in the top left corner, it has the word guest in it. Bob Peterson, the chairman of Carter Associates, is on the left, and Mr. Scott Stringer is on.
You can sit down. Sit down.
Thank you. It's old habit, Your Honor, 45 years.
I get it. All right. Anyone else?
Good morning, Your Honor. David Marmons, as Ms. Mitchell introduced me, on behalf of Kelly King, CL, and Oakwood Development. And we have our client, Kelly King, is at her office also and is present.
Very good. All right, then. All right.
One housekeeping matter, Your Honor, if I might. Once live testimony begins, I'd ask that the Carter defendants designate who their corporate representative is. And I'm assuming that's Mr. Taylor, but if someone else, that's fine. But I'd ask that both Mr. Peterson and Mr. Stinger be shown off of the video feed while there's live testimony going on.
All right. But we'll address that when we get to live testimony.
Thank you, Your Honor.
All right. Now, do you have a response to the motion?
I do.
Let's see. All
right. Thank you, Your Honor. Judge, first, what I'll say about the motion to dismiss is that the complaint has been amended twice since that motion was filed. Of course, we all know it's well settled under Georgia law that a amended complaint supersedes the original complaint. I have not seen a renewed motion to dismiss based on the new allegations, not the new allegation, the additional material included in the amended complaint, primarily the fully executed operating agreement. So I just make that at the outset as a procedural point that the original motion that they moved to dismiss has been superseded twice now. And I'd suggest to the court that their motion is moot. As to the substantive pieces of this motion to dismiss, Judge, it's pretty straightforward. We've got competing operating agreements. Plaintiffs say our version controls the company, and relationships and defendants say their version controls. But for the purpose of this hearing, for the purpose of this motion, plaintiff's allegations are to be taken as true, and the operating agreement attached to the amended and second amended complaints control. I heard Ms. Dunn mention when talking about the fully executed operating agreement that's attached to the last two amended complaints. She said, and I made a note of this because it's important. She said, set it aside for a minute. Well, Georgia law does not allow that version of the operating agreement to be set aside, as Ms. Dunn suggests, at the motion to dismiss stage. So taking that a step further, Judge, because the subject operating agreement is controlling, King and CL owed a fiduciary duty to plaintiffs. Quite simple. The Carter defendants' entire motion to dismiss is premised upon their argument that the version of their operating agreement is controlled. Let's talk about the stranger doctrine. There's been a whole lot of arguing and talking about the stranger doctrine. It does not save defendant's motion. The breach of fiduciary duty claims are specific to the internal affairs of Oakwood. And here's how you can make the distinction. If the claims were as Carter describes, Oakwood would own those claims for revenue flowing from the JV. And Carter certainly is not a stranger to that relationship, not plaintiffs. So Carter can't have it both ways, Judge. It can't argue on one hand that this is an internal fight between two partners and then they don't have anything to do with it. And in the same breath, argue that the claims are about the JV between Oakwood and Carter. Building upon that to argue that the stranger doctrine is a get out of jail free card. So they can't have it both ways. They can't say, oh, this doesn't have anything to do with us. This is between two partners at Oakwood. And then when it's time for them to argue that they're not a stranger to the dispute, then they flip and they argue that, oh, wait, this is actually about the JV. So you can't have it both ways. But there again, we're on a motion to dismiss, facts construed in the light most favorable to the plaintiff. That governs this as well. But if you look at it purely without even slander towards the plaintiff, it's clear that the aiding and abetting claims should stay. There was some argument about alleged failure to allege a purported failure of plaintiffs to allege Carter's malice and intent. And an executed conspiracy, we'd argue, is direct evidence of malice and intent. So you're going to hear a lot today, Judge, about a document that was executed in December of 2016. That document swore that Mr. Parks was not a part of the Turnerfield project, and it was signed by Ms. King and Mr. Taylor. So what we have, and you'll see this as the record unfolds, Judge, we'll have several years of communications, meetings, requests to meet, where Mr. Parks was an integral part of this team. And then right when it was time to close, they booted it. The Carter team went on record that, hey, we don't want Mr. Parks around this deal, to be a part of this deal. And if Oakwood, you want to go forward with this joint venture, you're going to have to affirm that Mr. Parks will not be a part of this deal. They conditioned signing the JV agreements on Mr. Parks being excluded from the deal. It's one of the most extraordinary things I've seen in my years of practice, Judge. It is a documented conspiracy signed by the defendants. Quite incredible. So let's talk about the $300,000. That was plaintiff's property. We've alleged it in the complaint numerous times, over and over. He controlled that money. He directed that it be put into the deal. And I don't see where this argument without support is coming from, that it wasn't his money. It was his property. And if you want to borrow from any number of Georgia areas or pockets of Georgia law, you can look at the law that governs conversion, as long as it's identifiable, right? It's property that can be taken, stolen, as it was in this case. We also addressed this pretty thoroughly in our brief. I think we cited the Z Space Inc. versus Dantana CNN Center case, which is 349 Georgia App 248, 2019. So we'll certainly rest on our argument as asserted in our written papers. The unjust enrichment, quite simply, asserted in the alternative. We've seen it in many cases, and such is the case with quantum merit as well. If the contract claims, for whatever reason, are not viable or get thrown out, or the jury finds against them, but nevertheless, the finder of fact finds that there were valuable services provided to the defendants, then you get to recover on the quantum merit or potentially unjust enrichment. So there's nothing unusual about that. Let's talk about the argument that the wire was not integral to the part, to the theft, was not an integral part to the theft. Judge, the wire was the manner and method in which they obtained the property at issue. If that's not integral, I don't know what is. It's central. It is the method in which they obtain the disputed property. So I don't think there's any question there. To the extent there's any question about the details, we feel like the complaint is pretty specific on what happened. And there's a tight shot group here as to the RICO claims. We're talking about December of 2016. We're talking about representations made to Mr. Parks. We're talking about, for example, what happened in Exhibit C of Carter's verified answer, where the emails detailing how much came into the deal, where it came from, Mr. Noel Khalil, and what Carter was going to do with it. It's pretty specific, Your Honor. And to the extent that we've all considered other documents attached to pleadings, the court should certainly consider that as well, because the defendants attached it to their answer. So with that, of course, as to the substantive claims being viable and not subject to a motion to dismiss, the conspiracy claims, attorney's fees, punitive damages as well must survive. Thank you.
Ma'am, do you want to respond at all or about anything?
Just very briefly, Your Honor, just a couple things. First, I don't think that it's contradictory for Carter to be considered to be a stranger to the internal Oakwood relationship, but not a stranger to the business relationship in which Oakwood and Carter were involved. I mean, if I enter into a business deal with an LLC, that doesn't mean that I all of a sudden have some sort of interest in the intercorporate operations of that LLC. I think those are two distinct issues, and I don't think that they are contradictory on their face. Just again, briefly with respect to the equitable alternative theories of recovery of unjust enrichment and quantum merit, I understand that they can be pled in the alternative. I don't disagree with that, but where a plaintiff has an adequate remedy at law, I think that's where these claims run into trouble here, because he does. It's money. The complaint is all about money. Money's everywhere in the complaint. That's what this case is about, and that's all this case is about. And finally, just as a housekeeping matter as well, we did see that plaintiffs filed a second amended complaint this morning where he's adding, Mr. DeBose is adding additional defendants. Those are other Carter entities, Carter affiliates. So just to the extent that any claims are dismissed against the current defendant, Carter and Associates, those entities are all in privity with Carter and Associates. So we would posit that the order should apply to them as well.
Thank you.
That's all.
If I might, Your Honor, within the scope of her last comment, just one quick point. The adequate remedy at law. I think you're going to see, and you probably have a flavor for this already, given the filings yesterday, how complex this transaction, this Turner Field project is, and how many entities have been formed to carry it out. Yeah, there may be a judgment, and ultimately we will look to recover a money judgment. But the question is, where and how? Who will have the money? Who do we have to sue? You know, what struck me in looking at that issue was, if you look back at the original verified answer from Carter, even a capable attorney like my friend Halsey Knapp over there had to drop a footnote and say, hey, we're researching who the proper defendant is. So that's what we're facing here, Judge. We're facing a few companies who spread out, multiply, and create a labyrinth of entities to receive funds. And it's almost a game of whack-a-mole, right? So fortunately, the affidavit from Mr. Stenger yesterday provided us with some information, but we're going to have to follow each individual rabbit hole to make sure that we've got the right folks. By the time that happens, who knows how many more agreements they can sign and say, hey, look, we're going to move the developer fees over here. There's nothing to stop them from doing that whatsoever. So that's what we're facing here. There has to be some type of intervention from the court to ensure, and we're talking about, in some levels, hard real estate here. So if the real estate is sold, then how are we going to track where it was sold, into what entity, where the proceeds went? We have to sue half the state of Georgia. So that's the concern here, the adequate remedy of law and the conduct of the defendants and frustrating Mr. Parks' participation and revenue due to him from the Turner Field project is what the court should consider on that adequate remedy.
Thank you. Does that take us to your motion for preliminary injunction?
Yes, Your Honor, unless you have any questions on the motion to dismiss.
No.
Okay. All right. I think we're at that point now where I'd like to call my first witness. So if we could invoke the rule.
Well, let me ask you about that.
Sure.
Is there something that these witnesses have to offer today that we don't already have in the record in the form of an affidavit or something like that?
Well, there is
in the affidavit, you don't need to call a witness.
I'm sorry.
If you already have an affidavit that summarizes the testimony of a witness, it's unnecessary to bring the witness. You can simply refer to the affidavit.
So the first two witnesses, Ms. King and Scott Taylor, there are no affidavits in the record from those. Well, there are, but I have my own separate questions for them. So, and they cover things that are not in the record already. So to the extent that Mr. King in particular, I don't plan to call Mr. Peterson. Mr. King in particular, who I do have some questions for, because he submitted an affidavit and they're within the scope of his affidavit, I thought it proper to exclude him from listening to the testimony of the other witnesses.
All right, then. I'm going to ask people who are the persons that are going to be testifying in this case to step out of the room and not discuss their testimony with anyone other than counsel. Are you concerned about somebody staying in the room as well? Now, if it's a representative of a party, I'm not quite sure. Yeah.
Exactly, Judge. Exactly. That's exactly right. That's why I asked Mr. Knapp who his corporate rep was. And the corporate rep, I'm assuming it's Mr. Taylor, but he can correct me if I'm wrong.
No, Mr. Taylor is my corporate rep. I have no intention currently to call either Mr. Peterson or Mr. Stringer. Mr. Stringer has provided an affidavit yesterday. It's simply as to ministerial matters as to which entities are involved in this transaction and nothing really else. So my intention would be, because he's the corporate representative, I think Mr. Taylor's allowed to be here. These other gentlemen, because I don't have any intention of calling them, it would be appropriate to leave in the room as well. Would you agree or disagree?
Plaintiffs have no problem with Mr. Peterson. We do intend to ask Mr. Stringer some questions, so we'd ask that he be excluded.
All right, Mr. Stringer, step outside that room. And
I'll be right back.
obviously you're not to, watch these proceedings on an available computer. Okay, I know that. Go.
I'm
All
gonna
right,
put them out in the reception area. I'll be right back.
great.
And some snacks, Halsey. Judge Gober, can I confirm that the court has received our exhibits?
Yes,
Thank you, Judge.
it's here. They are here.
Ready?
All right, ready? Ready?
Ready? Everyone ready?
I'm going to ask you to go ahead and swear your witness. Swear your witness.
King,
Yes.
Ms. King, do you swear or affirm that the testimony that you are about to give is the truth?
Yes, I do.
So you got it. All right. Good morning, Ms. King. My name is Von DuBose. I represent the plaintiffs in this case. Would you state your name for the record and spell it, please?
Kelly, Kelly, King, King.
Am I correct that you're president and CEO of Oakwood Development Group?
Yes.
What is your position with K. King Associates?
I'm the sole owner of the company.
What is K. King and Associates' role in the Turnerfield project?
I would have to speak to my attorney about that. I don't think that's been clear yet.
You don't know what what your company's role in the Turnerfield project is?
No, I haven't formally documented that, so no.
Okay, so are there any oral agreements as to K. King and Associates' role?
No. So I guess if your question is whether or not K. King and Company is an Oakwood Summerhill equivalent, that answer is no.
No, that's not what I'm asking.
Okay.
Okay. Yeah, I'm just, let me put it this way. What can you tell me, if anything, about K. King and Associates, or is it K. King and Company? Which one is it?
It's K. King and Company. Yes,
Companies, or is there just one?
K. King and Company.
Okay, K. King and Company.
Right.
So can you tell me anything whatsoever regarding K. King and Company's involvement in Turnerfield?
It has no involvement right now.
Have there been discussions about K. King and Company becoming involved in the Turnerfield project?
Yes, because I no longer use the Oakwood name. And so I formed this company and I have a credit card under the name of it.
Okay, so is the intention on your part to have K. King and Company come and fill the role that Oakwood was playing in the Turnerfield project previously?
Well, Oakwood doesn't play a role in Turnerfield. So.
I'm sorry, I didn't hear you.
Are you referring to Oakwood Development?
Yes.
It doesn't have a role in Turnerfield.
Okay, so is K. King and Company going to take the place of any entity controlled by you as to participation in Turnerfield?
I don't know. That's not the plan now, but I don't know.
Okay, have there been discussions to that effect outside of any discussion you've had?
No, it would only be discussed with me. It's my decision. No.
Ms. King, are you aware that K. King and Company is listed on some of the outward banners that you see at the Turnerfield project?
Yes.
You're aware of that?
Yes.
Right. And there, it's listed on the outward banners around the construction sites as participating companies, even though you have no formal agreement.
I have an operating, I'm sorry.
formal agreement tying K King and Company to.
Hold on, pause. I'm
No.
sorry, I do not mean to interrupt.
Mhm.
Did someone object, and where did you object at?
Megan Mitchell objected to the form to council's previous question.
Overruled. Go ahead, answer the question. Or
Thank you,
restate the
that's what I
question.
needed.
Let's
Thank you,
get the
Judge.
answer.
That's what I needed.
Thank you, Judge.
Yeah, so it was specifically only for marketing purposes because I told Bernard, I would say a few years ago, that the Oakwood name per se has no value to me for marketing purposes. And so I would no longer be using it.
Okay. Outside of K King and Company,
Mhm.
are there any other companies which you hold an equity interest that are involved in the Turnerfield project?
The entities which have already been disclosed to you are the only ones.
Okay. So outside of, and I'm assuming you've had a chance to review Mr. Mr. Stringer's affidavit filed yesterday?
Yes,
And of course, you're familiar with your affidavit, correct?
yes, I am familiar with my affidavit.
All right. So just to put a pin in this,
Yes.
outside of the entities named
Uh-huh.
in the affidavits, there is no other entity in which you hold an equity interest that is involved with the Turnerfield project.
No,
Okay. Are there any companies in which you hold an equity interest that is involved with any other project besides Turnerfield with the Carter defendants?
is there, could you say that again?
Put simply, are there any companies that you have an equity interest in that have deals outside of Turnerfield with Carter?
Seattle with Morehouse School of Medicine.
Okay.
Mhm.
What is Seattle's role as it relates to that project?
I'm primarily working on the retail development portion.
Okay, what are you doing with the retail development portion?
The leasing, the oversight of the construction, getting the spaces open.
What's Carter's role in that transaction, in that project?
Carter's a developer.
Any other projects?
No,
When was the agreement with Carter executed on the Morehouse project?
it would have been it would have been around the time of the opening. So I don't remember, I guess it was 2019 maybe or so.
Okay. Can I stretch to get you to give me a month thereabouts?
I'm sorry?
Can you recall what month generally?
No, but the announcement is in the public realm, and I would have executed the agreement around that time.
Okay. So let's go back to Oakwood for a second.
Mhm.
You're president and CEO.
Mhm.
How long have you held those positions?
Since 2014 for the operating agreement.
Now, you didn't found Oakwood, did you?
Did I think of the name? No.
Who thought of the name?
Bernard.
Bernard Parks.
Yes.
My question in particular was that you did not found Oakwood. Isn't that correct?
I don't think that's legally correct because when you look at the operating agreement, it has me as the responsible party for it. But I would have to defer to Attorney Williams on that.
What do you mean when you say the responsible party?
When Bernard and I started discussing Oakwood years ago before 2014, we both had a concern about people of color being involved in institutional projects. So that was the premise of the company. As I started to have the conversation with Bernard, and as you have seen from my response, the conversation started with me having a 25% interest till now where I'm the 100% owner. The basis of that was that during those discussions, it became clear that the liability and the person who had to be responsible for ownership that needed to have much more capacity than Bernard himself had. So for instance, Oakwood is not a standard LLC. It's subject to disclosures by government agencies and the direction of its managing partners. So in order for me to be an owner in Oakwood, I have to agree to periodic background checks, credit checks, criminal checks, all sorts of disclosures and ongoing compliance. And so it was clear during those discussions that Bernard would not or could not do that. And so that's why I'm saying that when Attorney Williams completed the final version of the contract, he had me as the responsible party since 2014.
When you say responsible party, are you equating that with 100% owner?
Yes, fully liable, fully responsible for Oakwood Development Group. That was why the agreement was stated as such.
And since that was the way things unfolded as you testified, you considered Oakwood your company?
Yes.
Okay. And Oakwood was your company without any input whatsoever from Mr. Parks?
No, I just outlined that I had discussions with him about the company, but his premise of what the company would be was not consistent with a company that needed to be involved in public-private partnerships. So he could not act in the role of an owner or in the way that I had to, so.
Okay. So I want to talk to you about your testimony that Oakwood started, it was controlled by you and was essentially your company. Go to Exhibit 1 with me and the documents that we submitted today.
So what do you mean by go to Exhibit 1? I only have this screen up on my computer. I was told not to have anything else open.
Okay.
So could you put it on the screen for me?
I've sent out hard copies. It's really difficult to work with screen sharing and.
Okay, so do I have permission to open up email and look for what you're referring to?
Sure.
Okay.
Well, I guess I can give that permission, huh, Judge? I don't know.
Judge, Your Honor, I think it'd be easier. We don't have hard copies of these documents. They were just emailed this morning. So I think it would be easier for the witness to see them on the screen and so that we can all be sure that Ms. King is looking at the correct document.
It would be, typically the way this is done is we get to all see the exhibit that the.
Your Honor, what can happen is who has control of this, whoever has control, I guess it would be Susan, maybe?
Susan's got it.
Okay, so Susan, if you would just click the share screen.
Yeah, hold it. I'll get with Susan. She.
Oh.
Yeah. I think I can get with Susan.
Okay. While he's doing that, Vaughn, do you see where, do you have, can you see if you have access to the share screen?
Yeah, I kind of do, but if you could see my setup over here, it'd be virtually impossible for me to manipulate it based on the way I'm set up over here. So that's why it would take forever.
Okay. All right, let me just. Okay, bear with me here, guys. See if I can do anything.
I could also have my paralegal call in and have,
Okay, hold on.
let me see if I can get her at least teed up.
Come on.
Yeah, it can be done, but because of the logistics, it's going to take a little while.
Okay, hold on. Let me see something real quick. Just give me 1 second, real quick. Are you saying exhibit 1, Vaughn? Shoot.
Yes, exhibit 1.
Okay, hold on. See if I can do it better this way.
Let's see.
I don't know if they're marked. Okay.
I could perhaps get my assistant up front to run. Give me just a second to have her sign on.
Which one is exhibit 1?
Probably not, but I'll be sure to say which one I'm working from so you can get to it quickly. Okay. Okay. So my paralegal is going to sign on
Okay, that's fine.
the exhibits.
I don't know if y'all can see that. Is that exhibit 1?
Yes.
Yes.
Okay, just until your paralegal gets here so I don't have to stop everybody. I'm just trying to help out here. So, let's see if I can, okay, I can scroll it up and down. Okay, you let me know and you direct me on what you want me to do.
Kelly, are you able to see?
Yes, I see.
Okay. Ms. King,
Yes,
see that exhibit 1 is an email from, I'm sorry, just look at the second portion of that. It's an email from Kelly King. The original message is from Kelly King to Brandon Williams, right?
yes,
All right, you see that as June 4th, 2014?
yes,
All right. Do you recall sending this email?
yes,
All right. And it talks about the terms of the contract between you and Bernard. Are you talking about Bernard Parks here?
yes.
All right. Attached is a summary of the deal pipeline.
Mhm.
That's a deal pipeline for what would become Oakwood Development, right?
Oakwood Development Group, yes.
Correct. Okay. Now I want you to go to the next page. Take a look at the mission statement there. We'll read that. You let me know if I read it correctly. Mission statement of Oakwood Development will be to a real estate investment company established for the family of Bernard Parks Jr.
Mhm.
Read that correctly?
Yes,
It doesn't say it's going to be established for the family of Kelly King at all, does it?
no,
It mentions only Bernard Parks Jr., right?
yes.
Check the form.
I'm sorry, I didn't hear.
Megan Mitchell objected to the form.
But your testimony is that you're the 100% owner of a company started for Mr. Parks' family.
Yes, so as you see, this is the first iteration of our discussion. When these projects start, you have several term sheets and discussions that go back and forth. So this was the point in which we were discussing that I would work with Bernard in a very small capacity because he was interested in being a part of real estate. As the discussions unfolded and it became clear that he did not and would not and could not complete the required disclosures, those discussions evolved. I've always been consistent about this.
Right. And once those discussions evolved, you then stopped dealing with Mr. Parks as it pertains to any Oakwood business. Is that right?
No, that's absolutely not true. So, oh, sorry.
Let me work through this a little bit more.
Okay.
So the mission statement, as you see it here in Exhibit 1, you're not aware of any document in existence that changed the mission statement, are you?
No, because it became obsolete once Bernard wouldn't take on any responsibility for being an active owner in the company.
My question was, you're not aware of any document that changed the mission statement from what is detailed here in Exhibit 1, right?
I actually don't, well, I don't remember that it was documented in a real estate contract, but the mission statement of Oakwood, I'm pretty sure this has been publicly stated, is to work with communities that have historically not been involved in institutional level real estate. So this is probably the only place in which you'll see something where it talks about being established for the family of Bernard Parks. Because again, it became clear that that was not something that he would be a part of doing.
Now, you understand the difference between what's represented to the public and what's represented amongst the parties in interest, right?
Yes.
Right.
Right. So that's my point to you, is that if you're asking about a mission statement would not be found in a real estate operating agreement. The only place that it would be is in public marketing.
Okay.
Yeah. So.
Understood. So in paragraph 10 of your affidavit, you state that Bernard Parks Jr. has also never held an ownership interest in Oakwood development, whether individually or on behalf of BPJ Enterprises. Did I read that correctly?
Yes.
Okay, so your testimony is that Mr. Parks has never owned an interest in a company that was started for the benefit of his family. Is that correct?
No, and his own attorney drew up the agreement. So I specifically stayed with Bernard's attorney, so there would be no confusion about this. The attorney clearly, retroactively, during those discussions as they involved, dated the agreement as July 2014, because it was clear Bernard could not be part of the EIN number because he had not filed taxes. He would not present me with the scope of work to show what his role would be. And he was refusing to complete any disclosures or be responsible to me for being compliant with the company.
Okay, so if everything occurred as you just described,
Mm-hmm.
No way that you could go and be pitching for business on behalf of a company that was in that much turmoil, right?
What do you mean pitching for business or turmoil? I don't understand what you mean.
You just described a lot of things that Mr. Parks wouldn't do to legitimize the business, right?
No, I didn't say he wouldn't do it to legitimize the business. I said he wouldn't do it to be a documented legal owner of the company.
Sure.
Right.
If he was refusing to execute documentation, you then should not be out trying to get business for a company that did not have all of its underpinnings in place, right?
Object to the
Did
form.
have it, yeah.
Hold on. State your objection.
Object to the form mischaracterizes testimony.
Overruled. Go ahead.
You can answer, Kelly, or
Okay.
Mr. DeBose. Do you need him to restate the question?
Yes, please.
Can you read the question back?
It might be a little bit hard to do that because I'm on share screen.
Okay. No,
Okay, Ms. Brown, Ms. Brown, Ms.
Yes,
Brown.
yes,
Ms.
sir.
Brown. Let me help us all out. Restate the question.
Okay, Judge, there you go.
no problem. So my question to you, Ms. King, is as you've described Mr. Parks' refusal to execute documents necessary for the company to operate, at that time, you would not have been out pitching for business under that company name, correct?
Yes, because I had the legal documents in place that Attorney Williams had drawn up.
Okay, and that operating agreement that you are referring to was executed on what date?
It would have been early 2015.
So from July 14 to January 15, your testimony is that there was no executed operating agreement for Oakwood Development Group.
It was not, but as you see from the final version, it was dated back to the company formation because they had to be a responsible party for the company.
Right, so it's dated back to July of 14, is that your testimony?
That's what Attorney Williams did, and that's what I've submitted, yes.
So it was executed in 15, but it was dated 14.
Yes.
Let's go to page 2, Exhibit 2. You recognize that as an email from you to an R. Dickerson.
Yes.
Okay, I'm gonna read the first sentence. And do you have any reason to doubt the authenticity of that email?
No, I don't have any reason to doubt this at this point, no.
Okay, and you say, first line, as discussed, Oakwood Development, comma, comprising myself and business partner, comma, Bernard Parks,
Mhm.
is very interested in working with Abyssinian Development Company.
Mhm.
Did I read that correctly?
Yes,
Yet you swore that Mr. Parks has never held an ownership interest in Oakwood, right?
yes,
Okay, but in November of 14, you're referring to him as your business partner, right?
right, that is perfectly common in my world. So Carter has referred to me as their business partner. I don't own an interest in Carter. I work with various consultants. I refer to them as business partners. That has nothing to do with the legal contract that's in place. So I have always been clear that I have,
Ms. King,
oh, sorry, yeah,
let me stop you. I'll ask a very focused question. It'll typically be yes or no. So
okay.
we can get through this a lot quicker if we just kind of keep that format. Okay. If you would work with me to Exhibit 3. So you recognize this email as a string between you and a Mr. P. Howard at Morehouse?
Yes,
Okay, first sentence to Mr. P. Howard, November of 2014. Tell me if I read this correctly. Oakwood, Bernard and I,
mhm,
Bernard Parks here, right?
mhm,
Along with Columbia Residential are responding to this RFP with Carter.
mhm,
I read that correctly?
yes,
And this one is even more specific than the last exhibit, right?
yes.
All right.
Can I not explain this at all?
Yes, you may. You can certainly
Yes.
explain your yes or no answer, correct?
Okay, so I have always embraced and clearly stated the fact that I have made repeated exhaustive efforts to work with Bernard. I was clear that when I started working in this capacity, that I would be working with people who had not been in the traditional realm of real estate in the way that I had been. So I was absolutely giving Bernard a chance. I gave him a chance from 2014 until 2017 to see the way in which he needed to operate to be a partner. So at no time did I exclude him from anything or diminish the fact that I was trying to work with him. And I have always been consistent about that. I've always said I have tried to work with him and help him to see the way that things needed to operate. So I have gotten these sorts of emails in front of me when I was on the stand before with Bernard. And it's only happening because he has no contract. He's never had a contract. And so I'm reduced to responding to emails which show my genuine interest in trying to get an agreement in place with him. So I'll just provide that explanation for the record, and I'll continue to go through these emails, which I have offered up and which I embrace and which show the best exhaustive efforts I tried in order to get him under contract and to behave in a way that an owner in the company needed to.
Okay, so this deal, this RFP that is referenced with Carter, is that the Turner Field project?
I assume that's what I was referring to, but I don't know for sure.
Can you take a look and see if you can recall?
No, that's Civic Center, right? So that's not Turner Field.
Okay, and the Civic Center deal did not happen.
No, it did not.
Let's go to Exhibit 4. All right, this is an email from you to Bernard Parks dated May 8th, 2017, right?
Yes.
Okay. Do you recognize that email?
Yes, I do.
Do you have any reason to doubt its authenticity?
No.
Okay, so the operating agreement that both defendants have said controls this case in Oakwood Development Group was executed in January 15, right?
Mhm.
That made you 100% owner of Oakwood.
Right.
That made you the person at Oakwood who would approve everything, right?
Yes.
So I'm going to read the first sentence here. And this is a full 2+ years after the time at which you claim to be 100% owner of Oakwood.
Mhm.
You say to Mr. Parks, please make it clear to him that you make all the decisions and your satisfaction is only required. I read that correctly?
Yes, absolutely.
Okay, so isn't it clear from that email that a full 2 years after the operating agreement that you claim controls Oakwood Development was executed, that Mr. Parks was still involved with Oakwood's affairs?
No, it does not. And so for the record, I don't claim, it is documented fact that that is the governing agreement, and it's been referenced throughout my conversations with Bernard for years. So you'll note the date on this is May 2017. That was after a particularly difficult time with me trying to work with Bernard. And so I was absolutely being sarcastic and frustrated because I think it's clear that he not only did not make all the decisions, he didn't make any. So when sorry?
I said, okay.
Okay, so when I wrote this is when probably on a daily basis, I would argue with Bernard because his behavior at that point had become a liability for me. He was proceeding down a road where I would have to daily tell him, this is not acceptable. You cannot ask a contractor to pay you if they're working on a site where you made an introduction to them. You cannot, threaten people. You cannot do all these other sorts of things. So at this point, I had completely stepped away from him, and I had also stepped away from other projects that I tried to work on with him. So at this point, I had been clear with Bernard because I was not trying to harm him in any way. I just had to separate myself from him and his actions, which were a legal liability for me. So all I said to him, and it's what I continue to say today, Bernard is free to go to Carter, to anyone else, go through his own vetting process, complete his own disclosures. And if it's determined that I owe something to him, it can absolutely be deducted from anything that I owe to him. But I cannot be in a position where he expects me to funnel money to him illegally, where he has no liability, where he has not done what he is supposed to do, because I am the person who's responsible. So there is nothing in me that wants to harm him, keep anything away from him. I gave him 3+ years to be a part of this company legally and to do what he needed to do, and he refused to.
So your testimony is that as to Exhibit 4, that you were being sarcastic when you made that statement?
That was a part of my testimony, yes.
All right. So let's go to Exhibit 9. Okay. Take a look at the first email, work your way down. Take a look at it. Let me know if you recall this email exchange.
Mhm.
Say yes for the record.
Yes,
And do you have any reason to doubt its authenticity?
no,
So you recognize this as an email exchange between you, David Nelson, and the team working on behalf of Oakwood on the Turner Field project, right?
right.
And if you'll go to let me focus you on Mr. Nelson's first email at the bottom of that screen, right?
Mm-hmm.
Here, Mr. Nelson is talking about the signature pages of the JV docs, right?
Mm-hmm.
Yes?
Yes,
And the JV we're talking about is the Turner Field project, right?
yes,
All right. And as you stated in your affidavit, those JV docs would involve Oakwood Summerhill, right?
Oakwood Summerhill and other Oakwood Summerhill entities, yes,
All of which you were 100% owner of, right?
yes.
Or either it's never Oakwood Development, it's you or either CL are 100% owner of these entities, right?
I'm sorry, could you say that again?
You were 100% owner of any of the entities that were related with the Turner Field joint venture agreement, right?
Yes,
So in response to Mr. Nelson's email, you sent an email and you wrote, let me read this, you let me know if I read it correctly.
mm-hmm.
I thought this was sent over based on whatever Bernard approved.
Mm-hmm.
Do I need to do anything else or are you sending to David? Did I read that correctly?
Yes,
You're talking about Bernard Parks
yes,
approving JV documents.
right,
Right?
right, which is obviously, right. So am I to explain now?
If Judge,
Yes, ma'am, you can go ahead and explain. Go ahead.
Okay, yes, so first of all, during this conversation, the other emails related to this aren't involved, but Bernard was to sign a letter saying that he would not be involved in the Turner Field project. So when I talked about what he approved was, in terms of what ultimately became a side letter that I signed, Bernard at that point had been completely clear with me that he knew he could not be involved in a project that involved private equity funds in particular, because he would not be able to get through the vetting process. So that's the background conversation that's happening here. And again, obviously, I'm not asking for Bernard to approve anything beyond that. And also the context of 2017 was that, again, I had been having years-long discussions with Bernard that he could not be a silent owner in Oakwood. He had to be documented. He had to go through the vetting process, and he had to agree to continuous ongoing compliance. And he was consistently refusing. So all of the conversations at this time were very tense with me and Bernard, and it was very argumentative, and the attorneys understood that as well.
let me ask you a question, Ms. King. When did you, over the course of the relationship with Mr. Parks as it pertains to Oakwood business, when did you realize that Mr. Parks was not going to agree to the requirements as you testified about today?
It evolved because I was constantly able to try to figure out a way for him to be involved in the company. So if he did not want to go through the requirements and disclosures of being an owner back in 2015, which would have been the most onerous, I still was open to him being a consultant. And he, throughout his emails, none of which you have shown here, references himself as a consultant. He sent me a W-9 saying that he wanted to be a consultant through Green Oaks Consulting. I was willing to offer him that. I was willing to work with him on a single family home development. I extended a line of credit to him. He defaulted on it and caused my credit cards to be canceled. So I was prepared to try to figure out some way for him to be involved in all these projects that I had discussed with him. When he refused to do what was legally required of him, I had to decide, do I either step away, in which case I did with the Columbia Residential Agreement, or do I allow him to move forward and for him to try to figure out this on his own? I knew that there was no way that once he had refused to complete disclosures where public bonds had been issued, where government agencies had already vetted the owners, where private equity and lenders had vetted the owners, that there was really no way for him to turn back that clock. But I could not convince Bernard. When Bernard gets going, he doesn't care about laws or rules or anything. So all I could do was to say, you're prepared, I'm prepared to allow you to move forward, Bernard, on your own. You can do whatever you want. If there's money that I owe you, all you have to do is take the contract that you say you have, put it in front of those owners, those government entities, and you can do what you need to do. But I cannot continue a structure where I am expected to funnel money to you and whereby you threaten me or sue me because I won't agree to do that.
Let me ask you this, Ms. King, on any of those required disclosures with respect to Oakwood business, is it your testimony that you were always truthful on those disclosures?
Yes, I was always truthful.
And on those disclosures that required you to disclose any equity partners in the company, you always disclose and fill those out accurately. Is that right?
I actually don't recall anything that asked me to disclose an equity partner. So if you go through my DBE certification, which I allowed Bernard to be a part of, it asks for anyone who is an owner. I don't remember the word equity being a part of it. If you go through the various affidavits that I had to fill out with HUD or any place else, it asks for the legal owner, in which case I had a legally binding contract, which Bernard had copies of repeatedly. But there isn't a difference the way that Bernard wanted it to be between someone who's an owner and someone who's getting distributions. So on all the documents that I completed, I put forth the truthful information at the time.
Well, let's go to Exhibit 5. Okay, and you may also recognize this, Ms. King, as Exhibit C to the defendant Carter's answer.
Mm-hmm.
You recognize that document?
Yes, I do.
That's your signature at the bottom, correct?
It is, yes.
And you signed this document freely and willingly?
Yes.
You weren't coerced into signing it?
No.
So when you signed this document, you understood that you were swearing and attesting and covenanting that Mr. Parks was not a part of the Turnfield Development Project. Right?
Yeah, yeah.
Specifically, you and Mr. Taylor, the other signatory on this document, warrant, covenant, and agree that Mr. Parks is neither a principal or agent of Oakwood Summerhill. Is that correct?
Yes.
You also, you and Mr. Taylor, agree that you will not permit the involvement by Mr. Parks in the business affairs of the property, Oakwood JV member, any of the joint ventures, etc.
Yeah. Yes.
So as to that last part, you were swearing that Mr. Parks wouldn't be involved in the same entity that you were referring to in Exhibit 9, which was a few days after you made this agreement, right?
I'm not sure what you're talking. I can give you an answer of this, but I'm not sure what answer you're looking for here. The two attorneys who drafted this, both were aware of the ownership structure of Oakwood. The email messages towards the closing were replete with references of me being the 100% owner of Oakwood Development Group in Oakwood Summerhill. If Bernard was not copied on something, I specifically forwarded to him so he could see it. Because again, Bernard is free and clear to go to Carter or to anyone else and say, I want to be a part of the process. I want to go through the vetting. I want to submit to compliance, but he won't do that. So there was absolutely nothing that I withheld. But for him to ask me to legally lie and say that he's a part of Oakwood Development Group is something that I could not do.
But in this document, you're saying that he's not involved in the affairs of Oakwood, and that's not true either, is it?
Object to the form as it characterizes the statement in the document. And Mr. DeBose, it might be
Restate your
helpful.
question. Restate your question.
In this document, Ms. King, you swore that Mr. Parks is not involved in the business affairs of the property and the Oakwood JV member and a number of other things, but that's not true, is it?
Yes, it's absolutely true. Bernard had no influence over anything that I did. I did what was right for the company. So I just don't know what you're getting at. I don't understand why we're going through emails, because if Bernard was an owner, all you'd have to do is put forth a contract and say, this is what he's owed. You'd be able to show compliance that he's completed. You'd be able to show criminal and background checks that he's completed. He's done none of that, and all of that's required. And he has stated to me on record that he knew he couldn't be a part of this project, and he knew he couldn't be a part of anything that involves a private equity fund.
This letter dated December 30th, 2016 states that you will not allow Mr. Parks to be involved in the business affairs of the property or the Oakwood JV member. And just a few days later, on January 3rd, 2017, you were on record seeking Mr. Parks's approval as to the JV documents. You can't square those two things, can you?
I actually can, and I just have explained that to you, that I was referring to the side letter. So I don't know what else you are looking for. This is actually very straightforward. Bernard's not an owner. He never wanted to be an owner. He never completed any disclosures. And to this day, I continue to say Bernard can move forward and do anything that he wants to do, but he has got to go through his own vetting process. I cannot accept money and funnel it to him, knowing what I know about him and his business practices. That is all I said. If he is owed money out of anything that I have, he is absolutely able to go and collect that. There is absolutely no reason that Bernard needs to go through me to receive anything.
Well, your position is that there's no entity in which he owns an interest that is a part of the Turner Field deal, right?
Yes, as I've repeatedly stated. But what else to say?
So let's focus back on Exhibit 5. Second paragraph, small letter I. It says Bernard Parks Jr. is neither a principal of Oakwood Summerhill LLC. Then there are a couple other words, and then it says nor an agent of Oakwood JV member, and is not authorized to act on behalf of the JV member. Read that correctly?
Yes.
And it says that you and Scott Taylor, the undersigned, shall not permit the involvement by Parks in the business affairs of the property. Right?
Yes.
Okay.
So can I respond here?
Yes, ma'am, you can respond.
So
No,
You can explain her, yes, go ahead. Go ahead, ma'am.
Okay, sorry, I thought he was speaking. So I don't know how many ways I can explain this letter. And there was no coordinated ploy between me, Scott Taylor, and Carter. By this time, I was clear that I was unable to work with Bernard as a partner who was someone who was under me, for whom I would be responsible. And there's a document in history which predates this letter of me having to step away from projects, specifically because Bernard threatened developers who were in a similar role as Carter. I had to step away from the 10th and Monroe project because Bernard gleefully told me that he threatened the developer, Jeff Fuqua, that if Jeff Fuqua did not pay him, he would hold the project up. I had to step away from Antioch because he told me that he was willing to pay the son of a board member under the table if they worked to approve the project. There was an ongoing history of Bernard casually being a part of behavior that was either illegal or unethical, and I was not going to continue to be a part of it. I freely signed this letter that Carter presented to me because it was my own feeling that I could not work with this person and be responsible for him. But that still does not preclude him from in any way going and talking to anyone that he needed to. I made sure he saw every document. He saw every agreement, which is why you're able to detail it to such a degree in your complaint. So no information was withheld from him. Bernard knew everything that I was working on, but I specifically said then, and I say it now, I cannot be a party who accepts money and funnels it to him when he is not a responsible person with whom I can do business. That's it.
All right. So focusing back on that one sentence about Mr. Parks not being involved in the affairs of the Oakwood JV member. At the time this was executed in December of 2016, if you look backwards, that certainly wasn't the case, was it? He was in fact involved in the affairs of the JV member.
No, Bernard was doing what Bernard wants to do. All I could do at that point was to focus on what I was going to be legally responsible for and what I would be party to. I could not control then, and I cannot control now, that Bernard will take any action, irrespective of any laws or rules which supersede it. So I believe I've answered your question in full at this point.
Was Mr. Parks involved in the Turnerfield deal prior to December 30th, 2016?
I don't know how else to answer this question.
No question. Was he involved?
Was he involved? He never gave me a contract. So that's the only way that he could have been involved legally. He wants to be a silent, undisclosed owner. That's simply not allowable.
So you went on for a couple of years arguing with him about that issue while you all the while racked up deals, transactions, projects on behalf of Oakwood, right?
No, in fact, I actually couldn't use the Oakwood name anymore because the first question I get from people when I would even mention Oakwood is Bernard part of it? And if so, we want no party of it. And that's why I clearly told his former attorney, he's welcome to use the Oakwood name. He can't use Oakwood Development Group because that's tied to my social security number. And my understanding is that he has a felony, which is related to a financial crime. So I won't agree to that, but he could absolutely be out today marketing Oakwood as a company of his. I would have no objections. I want no part of the Oakwood name. It only damages me and prevents me from being a part of projects. And I've had to pull out of projects specifically because people assumed Oakwood denoted some involvement with Bernard and they didn't want to deal with it.
Mr. DuBose, let's move on, okay? I mean, I certainly get the drift and the point that you're attempting to make. I don't know what else, where else you want to go with this witness, but on this particular point, you need to move on.
Sure, no problem, Judge. Thank you. This side letter at Exhibit 5. That Carter's idea?
Was it Carter's idea? I don't know what Carter's ideas are. I don't understand the question.
Who proposed the letter?
I don't know who proposed the letter. The letter was given to me at the time that it was dated. So
Who gave it to you?
Carter's attorney.
Who in particular?
I believe it was David Pritzker who sent it over.
Prior to executing that agreement, did you and Scott Taylor discuss it?
We did not discuss it at all, but I was not at all surprised about its presence. A few days prior to this, we had a meeting at Greenberg Traulich. I think there were about 10 people there at the meeting. And in that meeting, again, Bernard threatened Carter. So it was just impossible to work with him. And so this letter, again, is probably the third point at which I have documented with a developer that I cannot work with Bernard. I documented with Columbia Residential, and I gave Bernard an opportunity for about 2 years to move forward on his own accord, under his own name, with the equivalent of a Carter. They refused to work with him because his behavior was well known. I documented the same thing with Jeff Fuqua. So this was not a secret at this point that it was incredibly difficult to work with Bernard. He would not adhere to any sort of rules. He didn't care what was legal or illegal. And he knew that if he took a certain action, either Carter or I would be responsible for it, because the first thing Bernard would say is, I have nothing to do with Oakwood, if there was some legal ramifications to his actions. And he had carefully positioned himself to be in that position. And I hated to see it happen, because this is somebody I was friends with, childhood friends, our fathers grew up together. I did everything I could to try to get this guy to get on track and to be a legitimate legal owner in a project and in a company like Oakwood. And he just consistently refused. So again, I don't understand why I'm having to answer these questions, because I have told him he's free to move forward. He has every contract I've ever signed with not only Carter, with Columbia, with the Atlanta Housing Authority. He can go to them today and say, here's my documentation, I'm an owner, I want what's due to me. I would sign off on it immediately. But he can't do that because he knows he's not an owner, and he knows that he will not complete the required disclosures. And the disclosures that have been submitted, he can't retroactively go and try to address those.
Okay, Judge, Ms. King is covering the same territory over and over again.
Because you're asking me the same questions over and over again.
We could kind of stay focused. We can get through this a lot quicker, but I understand that, you know.
I will stay focused.
You have a question, Mr. DeBose? Let's just ask the question.
Sure.
And we can get through it that way.
All right.
Again, let's get off of this point. If there's some other issue you want to develop with this witness, start now.
Yes, I got a few more and a little bit more. All right, let's talk about Oakwood Development's dealings with New Columbia. So as president of Oakwood Development, you were the final decision maker on all matters involving New Columbia as well, correct?
Subject to their approval, because again, Oakwood is a company that does not have its own balance sheet. It does not put up its own guarantees. So I am completely under the scrutiny and the operation of the governmental entities and the managing partners with whom I operate.
You said their approval. Who is they?
Whoever the managing, in this scenario, would be Columbia's executives.
Okay, my question is specific as to Oakwood's relationship with New Columbia, right?
Yes.
All right, so you're the final decision maker on all matters as it pertains to Oakwood and New Columbia, correct?
No, I provided an explanation for you that it's subject to the approval of those with whom I work. I am not the final decision maker, no.
All right, and who else will be involved in any final decision?
Depending upon the question, I would have to go back to Columbia and ask them if they were okay with it.
Okay, so at some point, was Mr. Parks involved in making those final decisions on New Columbia business?
I don't know, no.
He's not involved at all?
No, that's why I was able to cancel the contract unilaterally without his involvement.
Okay. Now, you mentioned that paragraph 73 of your verified answer that Noel Khalil wired the closing money to Carter as a result of discussions and a prior business relationship between yourself and Mr. Khalil. Is that right?
Yes,
Is that right?
yes.
Was that a personal deal you had with Mr. Khalil or an Oakwood deal?
Well, first of all, I've never had any personal dealings with Mr. Khalil. It would have always been through Oakwood, but I'm not sure which deal you're referring to specifically.
Okay, well, in your verified answer, you swore to at paragraph 73.
Is it possible to put this on the screen so I know what you're referring to?
Uh,
I'm not sure what else I can say about it.
okay. Dawn, if you're on, can you put paragraph 73 of Carter's, I'm sorry, of the King defendant's verified answer up? And just to keep this moving, what I'll do is I'll come back to that while she's getting that teed up. Let's move to Exhibit 10.
Mr. DeBose, are you able to show that document?
Okay, Ms. King, Exhibit 10 is an email from you to Mr. Parks.
Mhm.
Okay, yes, for the record.
Yes.
And you're talking, do you have any reason to date the authenticity of this email?
No.
Okay. You're talking about a termination here in the the second sentence.
Yes.
So you then mentioned asking for a percentage due you,
Mhm.
Parks, and then the brand equity would go to him, right?
Mhm. Yes.
Right. And you're talking about the business of Oakwood Development here, correct?
No, could you show me this full screen so I can make sure I understand this is the Columbia Residential.
It's 18, right?
Well, in the second sentence, you say, I'm doing everything I can to make this termination easy by recusing myself on deals, plural.
Mm-hmm.
But you're talking about Oakwood Development's business in general, right?
Yes, I'm talking about projects, which I said to him, you can move forward with this on your own. I don't want to be involved.
Right. And
Right.
you use the language of asking for a percentage due to Mr. Parks, and you in parens say, which you certainly know. Did I read that correctly?
Yes, yes. So do you want me to answer this?
This is in August of 2017.
Yep.
Right? Which is well after the Turner closing, right?
Yep.
Which is well after execution of Exhibit 5, the agreement on December 30th, 2016, right?
Yes.
Yeah.
So can I answer this now?
That's all the questions I have on that, Judge.
So I want to can I answer this question? No?
Yes, ma'am, go ahead. You wanna
Okay.
explain why you said yes, go ahead.
So again, this email confirms what I have consistently stated. At this point in 2017, I have stepped away from projects that I discussed with Bernard and said, you can move forward with it. The percentage I'm referring to is 100%. I've said to him, I can't work with you. You can move forward. You can take 100% of whatever you feel is due to you. I don't want to be a part of any funds that you're accepting because your behavior is concerning to me. And when I refer to brand equity, it's what I said earlier, he could use the Oakwood name. What he refuses to accept is that the Oakwood name is of no value if you don't have a resume and someone who's willing to submit to all the required disclosures and compliance measures.
All right,
Okay. Exhibit 6. Take a look at this email string here at Exhibit 6. Let me know when you've had enough time to review it. Ms. King.
So all I can see is thanks Trey on the screen. I don't see the Okay. Yes, could you scroll down and then I can tell you them. Okay, so the context of, sorry?
On the table, ma'am. All right, I'm gonna ask you some questions about this.
Okay,
So you recognize this as an email from you to Trey Dye?
yeah, yes,
Trey Dye.
yes.
Who is Trey Dye?
Trey Dye was my attorney, Oakwood's attorney.
Was he Oakwood's attorney or your attorney?
That would be one and the same as I've answered you before.
So you consider Oakwood and yourself individually to be one and the same?
He was Oakwood's attorney. I don't know how else to answer that. So, and as I've discussed to you, I have the operating agreement that shows I'm the owner. So I don't know what else to say.
Look, you have no reason to doubt this email's authenticity, right?
No, and I'm happy to explain the email to you.
I'm gonna ask you some questions.
Sure.
Now work with me to the next page. I want to reference an email you sent before this one. And that page is the first page of the exhibit. And I'll focus your attention. I'm sorry. It's the last page of the exhibit. I apologize. And there's an email that you sent on May 8th, 2017 at 1:58 p.m.
Mhm.
And it says, no one ever explained to me how to operate under the constraints of the ladder. And I'm assuming you meant ladder there.
Right, right.
How do I address capital calls, et cetera, given that Bernard has to sign off on all bank account activity?
Sure.
And that was your email to Trey Dye.
Right.
And you were talking about Oakwood development matters.
Yes, so at this time, Bernard's first attorney had sent a term sheet to me saying that he wanted me to pay Bernard confidentially on projects. And so again, what you're not showing is the broader conversation, which is Bernard threatening me about sending money to him and money that I could not send to him legally because he had not completed the disclosures. And so again, my argument was Bernard, you go ahead, do whatever you want to do. I knew he had no access to any of my bank accounts and couldn't do anything, but I could not continue to fight with him on this. So, and then I was asking Trey because Michael Coleman, Bernard's former attorney, stated that he wanted me to work with an accountant to send Bernard distributions from Turner Field, irrespective of the side letter and irrespective of knowing that Bernard had not completed the required disclosures. So my concern was that an attorney would come to me and ask me to do something that he knew I legally could not do, but this was an attorney who was completely listening to what Bernard is telling him without vetting anything and asking me to take legal liability for wiring money to someone who cannot legally receive those funds.
Okay, you want to explain to the comment that Bernard has to sign off on all bank account activity?
I just explained it. That was part of the argument with me having with Bernard, that he knows he has no ability to do this, but he won't stop saying and doing what he wants to do, presenting that he is Oakwood, that he can do all sorts of things that he knows he can't do. So I just couldn't continue to go back and forth with him. But you can ask your client, does he have my bank account information? Does he sign off on it? The answer is no. But he felt comfortable threatening me and telling me that I was supposed to wire money to him.
We have paragraph 73 of the King answer available yet? John?
Yes, it's ready.
Okay, would you put that on the screen, please? Okay, so let me focus your attention on, scroll down a little bit, Dawn. It's actually, must be 70, well, wait a minute. There we go, 73. So I want to focus your attention on top of the screen that says, upon information and belief, plaintiffs at no time had any agreement with Khalil respecting the money wired to Carter on Oakwood's behalf. It says Khalil wired the money to Carter as a result of discussions and a prior business relationship between King and Khalil. Is that correctly?
Yes.
All right. So was that a personal deal you had with Mr. Khalil or an Oakwood deal?
It was the one that's outlined in the promissory note, so it's an Oakwood deal.
Which promissory note are you referring to?
The promissory note whereby it was late 2016 and attorney Mike Ward drew up a promissory note between me and between Oakwood Summerhill and I think it was Noel Khalil personally. I don't think it was his company related to the 300,000.
How much was that promissory note for?
300,000. No, it was for a total of 750, I think.
Right.
Right.
And that promissory note was never executed, right?
No, it wasn't.
So your testimony is that Mr. Khalil forwarded the money on your behalf pursuant to a promissory note that was not executed.
Well, that's the fact of what happened. He did forward the money over on Oakwood's behalf because I had been trying to work with Noel on an ongoing basis. And at that time, we were discussing having senior housing at the project, at the Turning Hill site. And I would presumably work on that with Noel.
So neither you or Mr. Khalil signed this promissory note, right?
No. And so, I'm sorry.
And that money has not been paid back to Mr. Khalil from Oakwood, has it?
Effectively, it has, because when I stepped away from the Columbia residential project, I was clear with Noel that if he wanted to apply that money to anything that he felt I owed to him, he absolutely could.
And you did that via email?
It was a verbal conversation, but it's the amount of what he would have paid me under that agreement is documented. And that was the agreement that I said Bernard, if he wanted to move forward with, absolutely could under his own name without me being involved.
And how was that payment documented?
Well, Noel had only, or Columbia had only wired $85,000 of the, I forget what the total amount of it, but it was the few $100,000 to me. And once Bernard started to threaten me that he wanted all of the money and he, and I had to send it to him, I told him that I, at that point, would recuse myself from the Columbia residential agreement, any monies due me, and that he was perfectly willing to go to Columbia and be vetted on his own and to get his own agreement in place. But he refused. And then by the end of that year, which would have been 2017, I had to report to Columbia that, again, Bernard was refusing to complete disclosures with HUD, and therefore he is considered a prohibited person and actually could not receive any of the funds from Columbia. So from that point, any funds which would have been due to Oakwood under that agreement would have 100% been mine.
Do you have an explanation for why Mr. Khalil paid the money in personally as opposed to New Columbia as a company?
Because the earlier agreement had a mentor protege agreement between me and Noel. So, that's the closest explanation I've ever seen, but no, you would have to ask him about that. And again, I have remained in contact with Mr. Khalil for years since then. And I have always been clear with him that I pay my debts, my credit report will support that. And if at any time he felt that after deducting the money that I could not earn under the Columbia residential agreement, if he felt I still owed him anything, I was perfectly willing to pay him. But the amount of money under that Columbia residential agreement that I forfeited exceeds $300,000.
Let's go back to Exhibit 10. Exhibit 10, you were talking about a percentage due to Mr. Parks in August of 2017, right?
Yes.
Mr. DeBose, can we show this document on the screen?
Yeah, let me, because we have to go back and forth on between your paralegal and me. I don't know if she has the other exhibit, so let me share exhibit 10 for you. Hold on.
All right, so as I mentioned, we were talking about the percentage due that you mentioned Parks in August of 2017.
Mhm.
Now, since the time you sent that email through the present, neither you individually or Oakwood has ever paid Mr. Parks any percentage due as referenced in that email, have you?
No, because I either forfeited moving forward with anything we discussed, or he refused to complete the requirements for projects that I'm involved in under Oakwood.
Other questions? Those are all the questions I have for Ms. King right now.
Your Honor, if I may, I just have a few redirect questions for Ms. King.
All right, go ahead.
Thank you, Judge. Ms. King, are you the owner of a company called CAL LLC?
Yes, I am.
What percentage of ownership do you have in CAL LLC?
100%.
Does CAL LLC own any other companies?
It only owns Oakwood Development Group LLC.
Does Oakwood Development Group LLC own any real property?
No,
Does CAL LLC own any real property?
no,
Does Oakwood Development Group LLC have any assets?
no, it has nothing.
Is Oakwood Development Group LLC involved in the Turner Field project?
No,
What entity is involved in the Turner Field project?
it's Oakwood Summerhill, Georgia Avenue, Oakwood Summerhill FS, I think, are the three.
Who are the owners of those LLCs?
I'm the 100% owner of all three.
Is Oakwood Development Group LLC a member of any of those Oakwood Summerhill entities?
No,
Do any of the Oakwood Summerhill entities that are involved in the Turner Field project have any ability to control the sale or transfer of real property in connection with the Turner Field project?
no, I have absolutely no control to do anything of that magnitude.
Are there other partners involved in that project?
Yes,
Are you a minority owner in that project or minority participant?
yes, I'm a minority owner in terms of participation and in terms of being a Black female.
So from an equity percentage as well as from a racial
Yes,
format. Okay, understood. So just to be clear, does Oakwood Development Group LLC receive any distributions from the Turner Field project?
no,
Now, Ms. King, you're aware that plaintiffs are seeking a preliminary injunction in this matter. Do you understand that?
yes.
If the plaintiffs were to receive an injunction in this case, can you tell the court what impact that might have?
The impact would be immediately and profoundly negative. The reason I say that is because this is a project that is catalytic for South Atlanta. Until this point, there was no real institutional interest or investment in this part of Atlanta. even when the RFP response was submitted, the only credible response came from Carter and Georgia State. And you get to where we are today, and you have, you know, people like Carter, myself, Healy Weatherholtz with extensive relationships and extensive experience with private equity and institutional investors who would normally not invest in this part of town, are not only, you know, 100% behind this project, but you now see additional development happening, and it has a ripple effect. You're seeing people who bought homes down there years ago when the area was very tough to live in, and they're now seeing home value appreciation. I've had conversations with them about wealth transfer that they never thought would happen, but for this project. There are childhood friends of mine and Bernard's who actually are working on the project. They have small businesses. They have to operate off of lines of credit that they personally have to guarantee. They don't have any capacity to withstand an interruption in this project, and they are incredibly grateful to have this project on their resume and to be able to learn from it and to be able to hire other community members. So I don't focus on myself, but I obviously am a part of several demographics and have those same sentiments from others. And so I do respectfully ask the court not to grant this injunction, because it would hurt people who have done nothing but live down there and try to earn a living and to be a part of this project. And if institutional capital gets nervous about coming into a project because something like this could deter it, it would be detrimental for countless amounts of people for generations. And, you know, our communities, Black communities, don't have the chance to, you know, we don't get second chances with projects or things like this. If this project is hurt because of one individual who had a chance over the course of years to be a legal part of the project, and they're now able to halt it, it would be incredibly unfair and harmful to many, many people. And no one who's a true owner or stakeholder of this project, and certainly no one who espouses the belief of Oakwood and its commitment to communities of color, would ever put their own personal interests ahead of what would hurt countless other people in this community.
Thank you, Ms. King. I have no further questions.
All right, Mr. Miller, who's your next witness?
All right, call Scott Taylor.
This camera on there. You can sit down, Scott.
You could have a seat. Yeah.
Focus, frame it. Center it. Bring it a little more.
Good afternoon, Mr. Taylor. My name is Vaughn DeBose. I represent plaintiffs in the case.
Where in your witness?
Yes, do you swear or affirm that the testimony that you're about to give here today is the truth, whole truth, so help you God?
I do.
All right. State your name and spell it for the court report.
Scott, S-C-O-T-T, Taylor, T-A-Y-L-O-R.
Who do you work for, Mr. Taylor?
Carter Associates LLC.
What's your position there?
I'm the president and CEO, also one of the principal owners of Carter.
I'm sorry, you tailed off on that last piece. Principal owners of what?
And one of the principal owners of the business, yes, Carter.
Right. How long have you held that position?
Gosh, Mr. DeBose, probably 3 or so years, 4 years, in terms of the exact title. Don't keep track of that kind of stuff.
Who's Bob Peterson?
Bob Peterson is the chairman of Carter, and he is also one of the principal owners of Carter.
So would you consider him your boss?
We're business partners.
Okay. What is K. King and Company's role in the Turner Field project?
They are a 5% owner in all of the activities that we're doing in Summerhill. We are, or a 5% participant in everything that we are doing. If that's the, as you referenced earlier, if that's the not the technical legal entity, I can't speak to that.
Okay, so K. King and Company is a 5% owner in everything that happens at the Turner Field project?
Mr. Bose, I can't speak to the specific legal entity. Again, we'd have to, but we can gladly provide you with all the documents in terms of what that specific legal entity is. Glad to do that, but I can't speak to that specifically right now.
Okay, so suffice it to say then, you understand that Kelly King is 100% owner of K. King and Company, right?
Again, I can't speak to the, I've not seen any documentation along those lines. I can't speak to the ownership of that entity.
So you don't know?
I do not know.
Did you talk to Ms. King about the testimony you would provide here today?
No, sir.
Is there an agreement between Carter and the King defendants or Oakwood to cover the cost of defense in this case?
I'm sorry, could you repeat that question, please?
Is there an agreement between Carter and the King defendants or Oakwood to cover the cost of defense in this case?
But not that I'm aware of.
Could there be one and you're just not aware of it?
I would have to, I do not believe so.
And if there were such an agreement, you would expect that you would have had to approve that agreement on behalf of Carter, right?
If in fact there were such an agreement, I think I would have been aware, yes, sir.
And in fact, you would have had to have approved that agreement, correct?
Not necessarily, no, sir. I mean, my business partner, Bob Peterson, and I have a very trusting relationship. There are certain things that are signed from time to time, but I think I would have been made aware of that.
Okay. So in paragraph 77 of Carter's answer, which you verified, it states that Oakwood transferred some of its interest in the Turner Field project back to Carter. Is that correct?
I'm sorry, could you please repeat that, Mr. Bennett?
Carter's verified answer says that at paragraph 77 says that in 2018, Oakwood transferred some of its interest in the Turner Field project back to Carter.
Your Honor, could we publish that so the witness can see and verify that's exactly what the answer says?
Sure. But I'll
Yes.
so we can keep moving that's the statement. Is that a true statement?
I do believe that was the case. And my business partner, Bob Peterson, handled those discussions and all the documentation, I believe, with Mrs. King concerning that matter.
How much interest was transferred back to Carter at that time?
I believe 5%, Mr. Bose, but I want to confirm that, but I believe it was in fact 5%.
And why did that happen?
I do not recall specifically. I do believe that it was Ms. King dealing with some other matters and needed to had a need for some capital. But again, you have to ask Ms. King that.
I'm sorry, I didn't hear that last part.
I believe you just need to ask Ms. King that for that specific reason.
Okay. What did Oakwood receive in exchange for that 5% interest?
Again, I would need to defer to either my business partner, Bob Peterson, or the records. We'd be more than glad to provide any and all information that you would need along those lines.
But as you sit here today, you don't know how much.
No, sir, I can't tell you the exact amount.
Can you ballpark it for me?
I want to say, Mr. Bose, maybe it was several $100,000. But please don't hold me to that. I'd ask that that be verified, and we can give you any and all documentation that you would need to confirm that.
Somewhere in the neighborhood of 300,000, you think?
Again, I would need just to confirm that.
Okay. Besides the Turner Field project, does Carter have any other deals, transactions, or projects with any company in which Kelly King is an equity owner?
Kelly is involved in our mixed-use project at the Morehouse School of Medicine. And she has provided some development services and leasing services. I know that she has been compensated in terms of receiving portions of development fees, but I cannot confirm that she is an actual equity participant in that, but glad to go back and confirm that.
Okay. Now, the Turner Field project is being executed on what I believe is approximately 68 acres of land. Is that right?
That was the original acreage. There has since been some additional acreage that we acquired separate and apart from that transaction, which is approximately correct. Yes, sir.
Okay. Now let me touch on something you just mentioned. This additional acreage that you acquired separate and apart from the 68 I just mentioned, does any entity in which Kelly King owns an interest have any rights or interest in that additional land?
Yes, sir. She is an equity participant in that, as well as a member in the recipient of development fees and lease fees, things along those lines. Yes.
I'm sorry, Mr. Taylor. When you finish, you kind of tail off a little bit, so I'm having trouble.
Okay, I'll try. I'll speak louder. How about that?
Hey, that's better. Thank you.
Okay, sorry.
Go ahead.
Would you like me to repeat that?
Please.
Okay, so what we refer to as Georgia Avenue, that was a separate transaction that our entity acquired later in January, I believe, maybe in February 2017.
What entity acquired it?
Again, I can't speak to that specifically, but I can assure you we have it all. It may have been a Georgia Ave LLC, but we can give you all of that documentation. Yes, Ms. King was a participant in that as well.
Yeah, and Vaughn, I know you're not doing this on purpose, but if you could wait till the witness finishes his response before you follow up or ask for further clarification, it would help the court reporter tremendously.
Sure. It's a little tough to kind of keep it separated on Zoom, but sure, I'll do my best. So what entity in which Kelly King owns an interest is involved in the Georgia Avenue aspect of the deal that you just described?
Again, Mr. Bose, I can't speak to that specifically as we sit here, but more than glad, and I believe that you may have received that information recently to show you that, but I can't speak to that specific entity right now.
Who at Carter would know?
Either my partner Bob Peterson or Scott Stringer, or we may have a few other members of our team that can tell you that specifically, but I can't this specific.
Okay. So let's go back to that 68, the original 68 acres of land. Now, most, if not all of that land was acquired by Georgia State from the Atlanta Fulton County Recreation Authority. Is that correct?
Yes.
So isn't it true that Georgia State or its entity or vehicle on which it is moving in this space, Panther Holdings, isn't it true that Georgia State still has fee simple title to some of that land?
They do, yes.
How much? How many?
It was approximately 14 acres was ground leased by a Carter, Oakwood, Healy, Weatherholtz entity. And since then, I think we may have released approximately 3 of those acres. And so that in a student housing transaction, and then there is also a multifamily transaction that is currently under construction that where there are another 3 acres involved. But in terms of what has been, again, released or not, we can give you that specific information. I can't speak to that technically right now.
Okay. And then of that original 68, there were entities affiliated with Carter that obtained title to some of that land, right?
Yes,
You know how much?
approximately 16 acres.
16 acres. Okay. Can you very briefly explain to the judge how that transaction occurred? Was it fee simple, or how was it?
In terms of the actual closing,
No, the transfer of the 14 acres from Georgia State to Carter, where Carter was the owner. Was there compensation to Georgia State? How did that happen? Can you explain it?
and so we had an agreement with the foundation in terms of what our entity would pay in terms of ground rent on a 99-year ground lease, and then what would be paid to acquire 16 acres fee simple simultaneously at closing when we closed on the overall transaction in January of 2017.
Okay. Now, question about the 16 acres that you have fee simple. What other entities besides Carter-related entities have an interest or rights in those 16 acres?
There, again, it's I believe it's Carter, Oakwood, Healy, Weatherholtz, FS, which stands for fee simple. And just to go back, and then there is a Carter, Oakwood, Healy, Weatherholtz, GL entity on the western side of Hank Aaron, which is the entity that controls the ground lease. So it's those two entities.
Okay, and then there's K. King and Associates.
Again, Mr. Bose, I can't speak to the entity that plugs into that operating agreement. Whether I believe it still was I believe it was Oakwood, Summerhill, FS, and then I think it was also Healy, Weatherholtz, Summerhill, FS that were the two minority interest partners. But I, again, would want to confirm that with you. I mean, we could easily do that.
Okay, how about Aspen Heights? They have any interest?
I'm sorry?
Aspen Heights.
Yeah, so Aspen Heights was a transaction that, again, involved approximately 3 acres where a student housing development was built. It's up and running. And there was a Summerhill related entity that I believe has a small profit sharing interest in that transaction in the event of a sale. But none of the Carter related entities or Oakwood or Healy Weatherholtz had anything to do with the actual development or ownership, except for that small profit sharing percentage. And again, glad to share any of that with you anytime.
Okay. Now, of all the Carter entities that you've referenced thus far in your testimony, which Carter entity is going to receive developer fees for the Turner Field project?
Okay, which Carter entity
Yes.
would receive fees? Again, I would need to confirm that specifically. I can't speak to that right now, whether or not it's our operating company or whether or not it goes to a different entity. But again, Mr. Bode, glad to share any of that specifics with you. Just can't speak to that specifically right now.
All right. How about any of the proceeds of any sale of real estate that may happen with respect to the Georgia Avenue acreage that you testified about? Which Carter entity, if that were to be sold, would receive those funds?
Which Carter entity?
Yes.
It would be again, I'd rather show you that or have us give you that specific entity, but I believe it would be a Carter holding Enterprises entity, I believe. But again, Mr. Bose, not trying to sidetrack anything there. It's just something that I don't spend a lot of time focused on. And again, not trying to sidestep anything, but again, more than glad to share all that with you.
Okay. All right. You go with me, Mr. Taylor, to what's been marked as Exhibit 5 for this hearing.
Yes, sir.
Heard Ms. King testify about this document.
Oh,
I'm sorry.
Oh, I'm sorry. Moving too fast. Taylor?
Yes.
Okay. Can I focus your attention on the last page of this document? Can you confirm that that is your signature?
Yes.
And you reviewed this document closely before signing.
Yes.
You understood the document.
Yes.
This document exists because Carter did not want Bernard Parks to participate in the Turnerfield project in any way. Isn't that correct?
I believe, Mr. DeBose, what we were doing in this document at the suggestion of council was just affirming the ownership.
Yes or no, that's a first.
Ownership.
Judge,
I'm sorry.
I can ask him to give me a yes or no answer first and then explain.
All right, he's allowed to respond to the question that he has, or that's.
It's a yes or no question, right? So answer and then explain. Do you need me to ask it again?
Yes, sir, please.
Okay. This document, Exhibit 5, exists because Carter did not want Bernard Parks to participate in the Turnerfield project in any way. Yes or no?
This document affirms the ownership of the participants. That's what this document does.
No yes or no answer, Mr. Taylor?
Well, Mr. Bose just trying to be very clear, again, when we were closing this transaction, we were trying to make sure that we affirmed the participation of those entities going forward. I think that's a pretty clear answer.
Go with me to Exhibit 17, if you will. All right, go to the second page. You can start at the email right there from Mr. Pritzker to Trey Dye, who we've already heard is Oakwood's attorney, and several other attorneys. Are you with me, Mr. Taylor?
Yes, I see what you're referring to.
Now, you recognize Mr. David Pritzker as Carter's attorney?
Yes.
Okay. Now, I want you, in that email that we just referenced, to go to item number 3. Right? Talking about the side letter. You recognize that side letter to be Exhibit 5, right?
Yes.
And apparently there have been an effort from Mr. Dodd to edit the side letter. Mr. Pritzker, on behalf of Carter, comes back and says the side letter must be in the form provided. I expected you would attempt to edit the draft I provided initially. Unfortunately, the form you provided is not going to work. The concepts addressed in the side letter are of the utmost importance to Carter. Read that correctly?
I'm sorry, do I read that correctly?
Did I read that correctly? Yes.
Yes, sir.
All right. And Mr. Pritzker in this email accurately reflected the views of Carter on this issue, correct?
Yes.
So we can go back to Exhibit 5 now. When exactly did Carter decide that it did not want Mr. Parks involved in the Turner Field project?
Again, what this letter states is the participants going forward. One of the probably events that precipitated this was when Ms. King referred to the meeting at Greenberg Trout, where there were, again, probably 10 or so people in the room. It became fairly clear to the Carter side that that the Oakwood entity going forward would absolutely be Mrs. King, but we wanted to just affirm what the participation was. And given Mr. Parks' behavior in that meeting, it would seem as though it was going to be pretty difficult for him to be a part of that going forward. And what this document does is, again, affirms that.
This document was prospective in nature, correct?
I'm sorry, could you just?
This document, Exhibit 5, was prospective in nature, correct?
Perspective, I'm not sure.
Prospective meaning forward-looking.
Well, this was a part of the all of the closing documents, and there were just a mound of them that were signed, I think, in and around closing when we were acquiring the land.
So to use your words, you wanted to make sure in Exhibit 5 that you would detail what was going to happen going forward, right?
Correct. Yes. Yes, sir.
Okay. Let me talk to you about how Exhibit 5 came about. Who was the first person at Carter to express the position that Mr. Parks should not be involved in the Turner Field project going forward?
Who was the first person at Carter to speak to that?
Yes.
I can't tell you that specifically.
This side letter, Exhibit 5, it was a side letter to a larger agreement.
Was it a side letter to a larger agreement? But I can't speak to that either. I don't recall.
Well, a side letter implies that it's an agreement on the side of another agreement. Can you tell me what other agreement this was a side letter to?
Are you referencing to an operating agreement? Is that what you're referencing?
I don't know. I'm asking you.
I can't. I don't know either. I'm sorry.
I'm sorry, what? You don't know?
I can't speak to what specific document this was tied to, if that was your question.
All right. Was this document provided to any third parties?
Please explain in terms of what third parties.
Any person or entity that is not an Oakwood or Carter affiliated entity? or person?
Again, Mr. Bose, I can't speak to that specifically.
Okay, was it provided to lenders or finance companies?
No, not to my knowledge. I don't believe that we have shared this with anyone.
Who at Carter would know that?
It would either be, again, myself, Bob Peterson, maybe Scott Stringer.
Okay. So you
Let me ask this question. What was it about Mr. Parks that caused you to want to have this type of representation made by Oakwood?
Your Honor, from the very beginning, when we had hoped to bring Oakwood in as a minority financial partner as well as a MBE, we were always very focused on that having a 10% ownership interest and 10% involvement and all of the financial participation, again, whether those development fees, leasing fees, asset management fees, you name it. And relative to sort of how the Oakwood participation went along the way, we had hoped that we would all find the roles and responsibilities that where people could add value and be very comfortable in terms of their participation in the project. And it became clear to us at the very end of this through Mr. Parks' behavior. He was pretty volatile, along the way, but we hoped that things would get to the point where we could find a way to work together. But at the very end, and I think that meeting at Greenberg Corral references where it became apparent that his behavior as well as his role in the project going forward could be detrimental to this incredibly exciting opportunity that we all had in front of us. And so again, Your Honor, what we were trying to do on the advice of counsel with this letter was just affirm that Ms. King was the participant with Oakwood, and that was that.
Well, you must have been under the impression before this letter was signed that he had some involvement in Oakwood. Is that right?
Well, Your Honor, we really didn't know exactly. I mean, we were dealing with Oakwood, and we believe that Ms. Ms. King was in fact in charge. But Bernard had, Mr. Parks had been around and had been pushing for a larger percentage. And so we wanted, again, to make sure that the entities that we were dealing with were in fact controlled by Ms. King, and that there would be no participation by Mr. Parks.
When you say he was fishing for a larger percentage, is that what you said?
No, he had been really negotiating or asking for a larger percentage of the joint venture from very early.
Was he asking for that on behalf of himself or on behalf of Oakwood?
Well, Your Honor, we always believed that that was Oakwood.
Okay.
And whatever the inner dealings with that entity, we were, that was their business.
All right, thank you.
Yes, sir.
Just a quick question about something you mentioned there, and I'll get back to my outline here, but you mentioned that you were focused as Carter on ensuring 10% minority participation in the Turnfield project, right?
When you say 10% minority participation, what do you mean by that, Mr. Bowes?
If I mischaracterize what you mentioned or what you testified.
That was a 10% financial partner, and obviously with Oakwood, they were a qualified or became a qualified DBE as a certified minority business owner, and so that was also obviously very positive for the project.
Right. So now you testified earlier that Oakwood's percentage has been reduced to 5%, right?
Been reduced. I mean, that was something that was requested by Mrs. King.
All right. So
that
that
was reduced, if you will, by anything but Oakwood's doing.
so that leaves 5% in your target participation. Right.
Sir, Mr. Bowes, when you speak of target participation, that was as a financial partner.
Okay, as a financial partner.
Yes, sir.
Have you brought any other minority companies on to fill that 5% void that you got back?
So the 5% ownership that you speak of, that's at the joint venture level, from our perspective, we have been incredibly interested in minority business participation in the project. In fact, almost $30 million has flown to minority, female, and small businesses since we've started this project. And we've achieved about a 30% MDE participation rate since we began construction on the project. And I believe, Mr. Bowes, we've hit that every quarter with the exception of one, unfortunately. But minority participation is incredibly important to us. And I think the results of that at the project reflect that without a doubt. In terms of the 5% ownership at the joint venture level, that those two are not directly related.
Right. So what you described was 30% participation in things like construction, security, and things like that in the project. But what we're focused on here today is the developer fees, which is a completely different focus, correct?
Any of the monies, if you will, that would be flowing through Oakwood, they would involve, that involve land sales, and they involve leasing fees, but they also involve capital calls for infrastructure improvements and things along those lines. So anything and everything relative to the management and the operation, of a large-scale mixed-use project, along these lines.
Okay, let me ask you a question about this misconduct you testified about, or behavior problems with Mr. Parks. Are you aware of any concurrently created documents that detail the issues with Mr. Parks' behavior?
I'm sorry.
Carter document problems with Mr. Parks' behavior?
Documented problems with Mr. Parks?
Yes. So you testified that there were issues with Mr. Parks that Carter at some point felt was too much. So what did Carter do to document those problems, those behavioral issues?
There were just a number of conversations and meetings, along the way where the behavior was really just sort of not in keeping with our company culture and sort of the way that we do business. And it culminated, Mr. DuBose, in that meeting at Greenberg Traurig in late December of 16. So I'm not sure if there would be any documents that would speak to that, but I think there are a number of my colleagues that could speak to just the behavior that I would reference.
So there were culture issues.
When you speak of culture in terms of speaking of culture relative to Carter and culture relative to just the manner in which we operate. We've been in business now for 63 years, so it's something that we've been very fortunate. But yes, it's just a really more style maybe than culture.
A little more style needed, is that right?
I didn't say a little more style needed. I was just saying maybe a certain way of doing business or a certain style, if you will.
Okay, but you would agree with me, Mr. Taylor, that just because you don't agree with someone's style does not mean that you can put them out of the deal, right?
You know, Mr. DeBose, we always looked at Oakwood of having the financial interest of that 10% that, you know, had, you know, there been really positive involvement and positive sort of momentum, because we were right at the doorstep of starting this project. But the fact that Mr. Parks was always looking for a larger ownership percentage, and that was something that we just never wavered from really the beginning. And so once we got, you know, it was apparent that that was not going to change, and we wanted to make sure that we affirmed, you know, with this document in terms of who the participants would be going forward.
Okay. So Carter has taken the position that neither plaintiff, BPJ Enterprises or Bernard Parks, has any equity in the Oakwood Development Group. Is that correct?
That's the position that we are taking. I mean, what, Mr. Bose, we look at this as a matter between, this is an Oakwood related matter, frankly, not a Carter matter.
Okay. And I can represent to you in paragraph 49 of your verified complaint that, or verified answer, I'm sorry, that Carter, you say that Carter did inquire of King if Parks or any entity partially or wholly owned or controlled by Parks was in any way legally affiliated with Oakwood. Do you recall asking Ms. Kim that?
I do not recall that. No, sir. I do not.
That's in your verified answer.
And again, Mr. Bose, I did ask, you know, along the way, I very easily could, but I can't recall that. But again, Mr. Bose, you know, this document that the letter that was signed in late December is something that, as we were moving towards closing, is what affirmed, you know, who the participants would be going forward.
Okay, I'll accept that, but I want to make sure that you understand when I say verified answer, that means that you swore to the accuracy and truth of the answers provided in that document.
Yeah, I don't have that in front of me. If you could help refresh my memory of that, or someone could hand me that.
We don't have to belabor it, but I just.
No, but Mr. Bose, I don't want to get, and in fact, I want to make sure we're clear on this. So if I can, you know, look at something or refresh my memory, this is hard to do.
If you want to look at it, sure. Dawn, would you put paragraph 49 of Carter's verified answer up?
And Mr. DeBose, you're referring to paragraph 49.
That's correct.
And so if you could restate your question, please.
Sure. So in paragraph 49 of Carter's verified answer, and it's verified by you, of course, there's a sentence that says, the second sentence that says, in light of this.
Wait. Will you wait till it comes up on the screen? It'll make it go a lot easier. Okay, go ahead now.
Look, okay, hold on, Halsey. I was looking at another document, so I couldn't tell it wasn't
fine.
yet. So I'm not trying to run him over.
I'm trying to make it easier, not harder.
All right, well, bark at me. All right, are you there, Mr. Taylor?
Yes, sir.
All right. So the second sentence says, in light of this opposition, Carter sought assurances from Oakwood that Parks was not a principal or agent of Oakwood, was not authorized to act on Oakwood's behalf, and was not involved in the business and affairs of Oakwood. You see that?
Yes,
All right. And my question to you, first of all, was, is that true?
and so the question is, did we seek those assurances? And
Yes.
yes, I guess we did.
Okay. What led Carter to ask Ms. King that question?
Again, it was just the behavior of Mr. Parks along the way.
All right. When exactly did Carter ask Ms. King that question?
I do not recall.
So back to Exhibit 5. You scroll down a little bit. So the second paragraph. Second paragraph. Small letter I, 2. It reads, the undersigned shall not permit the involvement by Parks in the business and affairs of the property, Oakwood JV member, any of the joint ventures, any of the company's subsidiaries, or any JV members affiliates. Read that correctly?
Yes, sir.
All right. Now, as of the time you signed this document in December of 2016, it would be accurate to say that Mr. Parks had in fact been involved in the business affairs of the property, Oakwood JV member, and the joint ventures. He was involved prior to executing this document, right?
But how would you describe involved?
All right. I can give you some examples. Let's go to Exhibit 12. Look at that email, Mr. Taylor, and let me know when you've had enough time to review it.
Yes, sir. Ready when you are.
Do you recognize this email?
Yes, sir.
Okay, do you have any reason to doubt its authenticity?
I do not.
All right. So this email, would you agree, shows that Mr. Parks was involved from the very inception of the Turner Field project, defining roles as this email details.
And specifically, I think we were looking just to define the roles of the participant being Oakwood.
Right. And you wanted to meet with Kelly King, Bernard Parks, Bob Peterson, and David Nelson, right?
Yes.
So he was involved there. All right, let's go to Exhibit 13. I'm sorry, just point of reference. This is 2015. All right. Go to Exhibit 13. Take a look at that email. Let me know when you've had a chance to review it.
Yes, sir.
Okay. You recognize that email?
I do.
All right. You don't have any reason to doubt its authenticity, do you?
No.
All right. So here you talk about meeting with Noel Khalil, and then Noel was to come speak with Bernard and Kelly, right?
Yes,
So it's clear there that Mr. Parks was involved in the affairs of the project at that time, correct?
and so at that time, again, Mr. DeBose, what we were trying to define, as Kelly referenced it, Ms. King referenced in her testimony, at one point, Columbia Residential was going to play a role, and there was a mentor-mentee relationship, we believe, between Oakwood and Columbia. There had been some interest around doing some senior housing and things along those lines. And we were trying to really get our arms around what would this potential master plan be? And again, we're trying to do our best to define what organizations and so forth would play a role in something of this type. So that's what we're trying to do in this meeting.
Let's go to exhibit 15. Take a look at that. Let me know when you've had enough time to review it.
Okay,
All right. You recognize this email?
I do.
Do you have any reason to doubt its authenticity?
No,
All right, this is an email from you to Bernard Parks, correct?
yes,
And to Bernard Parks only, correct?
yes,
And it's dated January 2016, correct?
yes,
So David Nelson in your office sends you an LOI comparison, right? At the bottom.
yes,
And he copies Bob Peterson, the chairman, right?
yes,
All right. And then you send that LOI comparison to Mr. Parks and say, call me when you get this so we can walk through it together to see if this gives you what you need. Read that correctly?
yes,
And that's sent to Mr. Parks only, right?
yes,
Not Ms. King. Correct?
yes.
Let's look at this term sheet, the next page. That's pretty much the entire scope of the entire Turner Field project, right?
Just for a moment, Vaughn, this email lists several attachments, but this exhibit appears to only have one. Have certain exhibits been excluded as attachments? Are you suggesting that that you're now asking about is an attachment?
Well, on what I have, it's only one, so I can't tell you. You know, a lot of these times, these attachments are actually just logos that show up. So
I'm going to object to this under the theory of completeness, that if you want to ask him about attachments to this email, that is required to have the entire communication, and I would object to questions on that basis. It looks
Well,
like
he can inquire as to what he has, and if the witness feels that this isn't a complete description of whatever relates to his answer to the question posed, he could state that, and then I would sustain that objection. So, what's your question, Mr. DeBose?
if you look at the designations, there's only one that's a PDF, right? So that's how you can tell which ones are documents, which ones are links to logos and things of that nature. But to the extent that you feel like this may be incomplete, Mr. Taylor, do you recall any other attachments to this email that are not represented here in this exhibit?
I cannot, but I cannot state that there weren't any. So I cannot confirm that.
Okay, and then indeed in Mr. Nelson's email to you, He doesn't reference multiple attachments. He just referenced the attached LOI comparison, right?
That's what the email states, yes.
Okay. And then your email to Mr. Taylor, to Mr. Parks, you say, call me when you get this, which is singular, correct?
Correct.
All right. All I have on.
I'm sorry, is that the end of your examination?
Oh, no, that's all I had on that, that particular. I'm moving pretty well,
I
Joe.
look forward to the end of the examination.
I
I'm
do as
serious,
well.
because we have another matter at 1:30. and,
Okay, I'll hustle up.
Step on it.
All right, let's,
Your Honor, I'm gonna need a bathroom break at some point too.
Yeah, Your Honor, I'm sorry. I hate to break
I'm
it.
sorry, absolutely.
That's okay. Can we have the
Listen,
10? Just give me 10. Just
You're
to,
more important. You're the most important person on this deal. So
Right.
you go ahead and take yourself a 10-minute break,
if
okay?
y'all don't mind, I appreciate it.
Okay, everybody else needs to stay where they are though. So go right ahead, man. No, 10 minutes.
Thank you.
Y'all thought he was serious.
I know you did. Okay. So we're still missing some. Who do we need? Anyone?
Plaintiff here, counsel, plaintiffs here.
All right, well, let's get started.
We're going to zoom in on Mr. Taylor here. There you go.
There you go. Yeah,
There you go.
can't start without him.
There you go.
Let's go.
All right, exhibit 14.
Yes.
And Mr. Taylor, when you have a second, take a look at exhibit 14, which is an email string, and let me know if you recognize this email string.
Yes, I do.
You see in that email string, there is a Mike Ryman.
Where there's what?
There's an individual on the email string named Mr. Mike Ryman, or is it Ryman?
Yes, Mike Ryman, yes.
Who is Mr. Ryman?
He is a public relations professional with a company by the name of Cookerly and Company here in Atlanta.
Okay. Who hired Cookerly in this instance?
Cookerly at that time was on a retainer for Carter.
So let's go to the bottom or the last page of this email string, which of course would be the second to last page. Of course, would be the earliest email. The second and third to last page. You see an email from a Max Blau,
Yes,
July 8th, 2015.
yes,
So Mr. Blau sent some questions to Mr. Ryman, Mr. King, and Mr. Parks. And then Mr. Cookerly then sent Mr. Blau's questions to Malloy Peterson. You see that?
yes.
Ms. Peterson's with Carter?
She is no longer with Carter, no.
Okay, what was her role at that time?
She ran all of our marketing and public relations and communication.
Related to Bob Peterson by chance?
Yes, daughter-in-law. He definitely claims her.
All right. So Ms. Peterson took her July 9th, 2015 email that was sent at 10:14 and says, I just went ahead and took Kelly's answers then based on the facts, based on the other facts I do know, took the liberty of inserting my thoughts in for Kelly and Bernard. You see that?
Yes.
Can you explain how Ms. Peterson, as an employee of Carter, can take the liberty of revising the history of Oakwood and how it started?
I can't speak to that right now.
Okay. Isn't it clear from this email that Carter is participating in an effort to come up with a story to the press that would explain away Mr. Parks' participation in the Turner Field project?
If I recall, what we were trying to do was support Oakwood.
I'm sorry,
With the best intentions.
I'm sorry, I had a commotion in my hallway. I had to close my door. I apologize.
No problem. Mr. DeBose, my answer to that is we had the best intentions of supporting Oakwood. That's it.
Okay, and in the best intentions of supporting Oakwood, you were attempting to support Mr. Parks as well?
We were supporting a media inquiry at the time, and we were just providing some of the resources that we had to support that, to respond to that inquiry.
Okay. And then a couple lines down, Ms. Peterson says, also, how do we say enough? We've cooperated with you on 5 separate inquiries from you on Oakwood and have this be the last of it from us. You see that?
Which one is that, Mr. DeVoe?
The second to last paragraph, it starts with "for Mike." Do you agree that we should submit this all in writing versus a call? And then she says, also, that sentence, how do we say enough?
I can't speak for Ms. Peterson on that, and I can't recall having that conversation. Or
Okay,
having a conversation about it.
okay, but you don't have any reason to doubt that Ms. Peterson was correct, that Carter had received 5 separate inquiries from Mr. Blau regarding Oakwood, right?
That easily could have been the case, easily.
So it's fair to say then that Carter was under some pressure from the media regarding Mr. Parks' involvement with the Turner Field deal, right?
There were media inquiries relative to Oakwood.
Let's look at Mr. Blau's original email, which is on the 3rd to last page. The first question he asked, why did Mr. Parks, a co-founder of Oakwood Development, leave the firm he helped found 1 year ago and originally incorporated to a home that he owns? You see that?
Yes.
Okay, at no point in this email exchange did anyone from Carter or Oakwood refute this statement that Mr. Parks was a co-founder of Oakwood Development. Did they?
Is the question, did we dispute that?
Correct. No, that's not disputed by anyone in the proposed answers to Mr. Blau's questions.
No, we were working under the pretense that Mr. Parks and Ms. King were both a part of Oakwood.
Okay. Last few questions, and I promise. Let's go back to Exhibit 5.
I'm sorry, sir?
Go back to Exhibit 5.
Okay.
And as you testified, Exhibit 5 was put in place to ensure that going forward, Mr. Parks would not participate in the Turner Field project, right?
Yes.
All right. How, since the time this document was executed, have you and Ms. King, as the signatories, ensured that Mr. Parks has not participated in the Turner Field project?
And so what do you mean by that specifically?
Give me any specifics that you and Ms. King have done to ensure.
I do not have any specifics.
But you do testify here today that you have, since signing that, complied with the terms of the agreement.
From the Carter, the related Carter members, I do not have any knowledge of Mr. Park's participation in any of the Turner Field related or Summerhill related matters.
Right, and you ensured that Carter complied, or you complied with that agreement?
To the best of my knowledge, yes, sir.
Okay. All I have, Judge.
Very good. Do you have any other witnesses?
I do not. Well, I think we can bypass Mr. Stringer. I did have some questions, but in the interest of time, I think we'll wrap it up.
Very good. All right. Now, with respect to, I'm sorry. Do the defendants have anything they want to address with respect to the evidence that's just been presented, or do you have any evidence of your own you would like to present in opposition?
Your Honor,
What's already been elicited from the witnesses?
Your Honor, I have about 7 questions or areas I need to cover with Mr. Taylor on redirect. I assume that Mr. DeBose will agree that if I agree to admit all the documents he's tendered but not moved into evidence yet, that he'll agree to admit all the records that I forwarded him yesterday in my notice of filing and amended notice of filing, and both those come into the record. We can complete the record as to written submissions.
What I would say to that, Your Honor, is that for the purpose of the record being reflective of what was covered in the hearing, I think it should only, to the extent you want a formal motion to move into evidence all of those exhibits that were addressed by my examinations, I so move right now. But I would suggest that it's proper that the record only contain exhibits that were addressed, authenticated, and questioned. But to the extent there's any issue, there's a notice of filing with all of those exhibits in the record anyways. Probably neither here nor there.
How many documents are we talking about, Mr. Knapp?
My original notice of filing had an affidavit from Mr. Stringer that talked about the various entities. We affirmatively stated what were the entities involved in this project from the Carter's perspective. That was Exhibit 1. And then I had 10 other exhibits that were mostly agreements, and made up the timeline here because the discussions, many of which predated the RFP that went out for this project, and almost all those emails that we've been looking at predate the RFP going out and were exploratory in nature, take on a different view when you understand the chronology.
Well, let me just stop you for a second. With respect to the documents attached to the Stringer affidavit, I see no reason not to admit those things. That was in response to the motion, was it not? Yeah.
Thank
So
you.
those are certainly be admitted. But now, what other documents besides those?
We have a series of documents to start in May of 2014, which is the agreement between Georgia State and the Carter affiliate, the organization of Oakwood Development Group on July 10th, the RFP actually being issued on October 5th, 2015. We have then the response that was actually filed by Carter, exhibit number 6 on November 20th, 2015. The award of the project to the Carter Georgia State / Oakwood team, a letter of intent then in 2016 between the city of Atlanta selling the property to Georgia State under the Panther Holdings documents, the actual purchase which took place on August 18th, 2016, and then an email of January 5th, 2017, which reflects the the wire that has been the subject of some discussion as to who it's from and whether or not it was a theft.
Okay. Well, Mr. Du Bois, are you suggesting that these aren't what they purport to be? These
No,
documents?
I mean that I'm not disputing the authenticity of any of them. I think in some shape, form, or fashion, they're in the record in other places anyway. The only question I had is as to, if you're talking about this transcript and what was addressed in this hearing, I don't think it does to have a whole bunch of documents that were not addressed during the hearing attached to the transcript. That's my only point. They're everywhere else in the record.
The transcript's the official record. Doesn't do me any good to have them in the clerk's office and not admitted as part of the hearing. I'm trying to shorten the hearing.
All right, I'm going to allow them for whatever value they have. Obviously, if nobody's going to discuss them or refer to them specifically, I don't know what value they could have, but let's go ahead. Ask anything else?
Just for the record, Judge, I'll preserve my objection for the record.
That's fine. Anything else, Mr. Knapp?
Like I
In the way
said,
of
I have 6 or 7 questions that I'd like to handle.
Yeah, I understand that. In the way of documents, is that it?
That's it.
And then, Judge, when
Questions?
he gets done, I just have 2 minutes of a summation on the motion.
I understand, but we're not going to get to a summation till we finish this part. You know? Okay.
Understood.
All right, go ahead, Mr. Knapp. Ask your question.
Okay. First, Mr. Let's put the camera on witness. Thank you. Mr. Taylor, are there any MBE requirements for this project at the joint venture ownership level?
No.
Okay. So are there any MBE requirements lower down in the performance of this project?
Again, if I recall, the RFP did ask for an MBE plan, of which we offered one using, and it was negotiated, frankly, after we were selected, where we would use our best efforts to achieve, I think it was a 28% MBE participation, percentage of which mentioned previously, we have achieved a 30% MBE participation for every quarter since we started on the project, except for one.
Okay. Now, you were talking that Mr. Parks was pushing for a greater percentage. What percentage was he pushing for of the joint venture project?
What we had initially proposed was 10%, and at the time, my memory serves me that he was asking for in the neighborhood of 30%. That may have changed a little bit, but I do recall that number at some point.
Did Carter ever move off the 10% it was offering?
No.
You spoke about having a difference of culture or style, and I want to be clear here, and this is a difficult question, but I need to ask this. Were your culture or style differences because of the fact that Mr. Parks was Black and you were a white organization?
Absolutely not. Heavens no. What I really would have meant by that was a professional style. You know, we were accustomed to dealing with large institutional investors, banks, private equity funds, attorneys, and so it was that professional behavior and professional style.
What was it that you understood was the strength of your proposal to the city of Atlanta and Atlanta Fulton County Recreation Authority in responding to the request for proposal?
We believe we created a significant amount of value when Carter was able to sign an exclusivity agreement with the Georgia State Foundation. We did this in May of 2014. What that really allowed us to do was that Carter was not going to pursue this project with anyone but Georgia State, and Georgia State was not going to pursue this project with anyone else. We had no idea what was going to happen at the time, but we believe really at that point, that's where we created the most value, was when we controlled Georgia State University.
And did you talk to a number of different organizations and people about the prospects of this project before the RFP was actually issued?
So do you mean MBE participants? Do you mean contractors? What do you mean specifically?
Without limitation.
We did have conversations, but we spoke initially with Noel Khalil at Columbia about coming in as an MBE, but also as a very accomplished developer. We sort of just got to the point where it just looked as though it wasn't going to make sense for Columbia, but we did talk to him specifically, and I can't recall, but we may have had other conversations.
Were there any advantages to the city of this deal being financed through private sources rather than tax credits and other public funding?
Something that was very important to not only the city, but Fulton County was as much of this to be developed privately. because for the last 20 years, the property had not been on the tax rolls. And so the percentage of the property that would be developed privately, what we agreed to ultimately was 75% of the property would be developed privately, meaning that it would go back onto the tax rolls. And there besides we have a property tax abatement on one small parcel, besides that, there've been no public participation.
Judge,
And
just
what experience it, go ahead.
objection to the last question as to his personal knowledge of what the benefits to the city would be, but just want to make my record.
Overruled. Go ahead.
What experience did Carter have in terms of dealing with the university need for athletic facility and or university housing?
Probably since the early 90s, Carter's been incredibly involved up until when the RFP was done. We've probably done several $1 billion worth of work on or near university and college campuses with any and all types of athletic facilities, research buildings, academic buildings, infrastructure, parking, you name it. And so the prospect of our potentially being able to bring our private development of doing and executing large scale public-private mixed-use development, along with our education experience, really just positioned us incredibly well to propose on a project of this type and magnitude.
Could the court reporter please bring up plaintiff's exhibit 14? It was the last exhibit that was shown to Mr. Taylor as part of his cross-examination. And go to the very end and let's work forward. The earliest email looks like an email from Max Blau on July 8th of 2015 to Mike Ryman. You see that? It's a long email. You've got it there. Okay, right there.
Okay.
Now, is Bernard Parks on this email?
Not that I can see.
Who's the CC?
Oh, I'm sorry. Oh, yes, Bernard is on that email. Apologize, I couldn't see that.
So this discussion about Mr. Parks' role is not being concealed from him, is it?
Again, the email was addressed to him. Yes, that's correct.
And then go up to the next item here, next email in this chain. And again, Mr. Parks is shown on this email as well, correct?
Correct, yes.
And then go up to the next email in this chain. And again, Mr. Parks is shown on this, correct?
Yes, that's correct.
And then you have the final say as to what's going on here in this top email, correct?
Yes.
And read into the record what you said.
So from Carter's perspective, I would suggest that we not speak to Max any further. We have been most cooperative to this point, and we are done.
Thank you. Now, what would the impact of an injunction be on this project and on Carter and its role in this project?
You know, up until this point, there's been almost $1 billion worth of economic development activity in what's commonly referred to as the former Turner Field. Not only what's come out of the Summerhill development, of which Carter, Oakwood, and Healy Weatherholtz have been driving, but also economic development that has occurred by other institutional investors, such as AIG Global Real Estate, the Trammell Crow companies, doing Class A institutional grade investment around us. And so there has been, as mentioned, almost $30 million of minority business enterprise work. There has been ice cream shops, coffee houses, pizza, hot dog places, donut places, all that have made created jobs for the neighborhood, as well as created businesses. A number of the merchants along our Georgia Avenue development have come from the neighborhood. We have also done a large scale market rate multifamily project that is under construction right now, where there's an opportunity for that to be sold, that if we were to miss this window because it happens to be in a federal opportunity zone, it would cause incredible damage to our institutional partners there. And finally, maybe most importantly, we're in the process of signing a lease with a national grocery store. And Your Honor, from the very first meeting we had in the community, in the neighborhood, back in the spring of 2014, the neighborhood and the community wanted a grocery store, and we were in no position to be able to commit to being able to bring that grocery store. But we were on the 1 yard line. In fact, I think that the lease is in the grocer's hands to be signed, where we would come out and make a public announcement on a 50,000 square foot grocery store with a pharmacy. We'd have 35,000 square feet of additional shop space, where we already have a tremendous amount of interest from healthcare providers and other service providers that would come into the neighborhood. That project alone would create almost $15 million of minority business participation. And so with the momentum that has been created right now, in the area, not only by the state, Georgia State University, with the redevelopment of what's now called Center Park Stadium. They're now building an $85 million convocation center to the north, with all the retail, the residential, and the commercial that we have going. And most importantly, this grocery store, it would harm this community that has needed this boost for decades and decades in ways in which we can't describe. And I can just share on a very personal level and almost an emotional level for our partners that have been involved, the impact this has had on children and on families that have not had this type of experience for decades. It's just been so rewarding to our partners and our company. We're down there every day picking up trash and trying to help. And on top of that, the work that we have done in parks and in green space and things like that would stop because of the economic impact that we were able to generate and then be a part of this community, which we are just so incredibly proud and honored and privileged to be a part of. An injunction along these lines would just, it would cause unbelievable harm. And so it's something that's, the project is unbelievably important to us and to every single one of my colleagues at Carter, as well as our partners, Mrs. King and Healy Weatherholtz. So it would be a really big deal.
I have no further questions, Your Honor.
Mr. Du Bois, you got any follow-up?
Very quickly, Your Honor, that parcel of land where the Publix is going to go, who owns that land right now?
The parcel of land that you're referencing where the grocery store is going to go, we're under a confidentiality agreement, not speak to any specific companies, but that is, I believe, a Carter Oakwood Healy Weatherholtz entity. Again, Mr. Buzz, I can't tell you exactly which entity that is, but I'm more than glad to share that with you.
Okay, so that's who owns that piece of land?
Yes, sir. It's a Carter Oakwood. It's a cow, as we call it. It would be one of those related entities.
Okay. Nothing else, Judge?
Anything else?
Nothing else, Judge.
Mr. Taylor, tell me, if you can, in terms of Oakwood, what sort of financial interest do they have in the project at this point in terms of an amount of money?
Your Honor, I don't want to interrupt, but Oakwood there are Oakwood entities and there's Oakwood Development Group, and I want to be sure that you're focused on those distinctions so that you get to the subject that you'd like.
Why don't you help me out then, since you're more familiar with those entities? I'm talking about the entities that are involved in this particular motion.
It originally, there
And the
was
plaintiff's
Oakwood
claims.
Development Group, and then it proceeded from there. Do you have any understanding of that, or is that?
Yes, and I think, Your Honor, I mean, there are separate LLCs that are part of the, our retail, that are part of the multifamily, that are a part of the simple, as well as a part of the ground lease. And again, I'm not the numbers guy, the brains of the operation financially, my partner, Bob Peterson. He could probably speak to that off the top of his head. I just can't. So I apologize for that.
Okay, so that's a long way of saying I don't know.
Yes, sir.
All right, thank you.
Better
All
said.
right, thank you. All right, at this point, I expect to hear from Mr. Du Bois about his motion and summary, and then we'll.
Okay, and I'll be here, and thank you for your indulgence in the hearing the motion.
Listen, I mean, yeah, I indulged you. No, I didn't indulge you. You're. It's like you're entitled to this hearing. So go ahead.
We certainly appreciate your time, Jeff.
I know. Go ahead.
So we've seen extensive written evidence of Mr. Park's interest in Oakwood. There's no dispute. Even Mr. Taylor testified today that they understood him to be a part of Oakwood. Ms. King repeatedly represented the third parties that Mr. Parks was her partner in Oakwood. And even after the time in which she claimed to have been cemented as a 100% owner of Oakwood, July 2015, or I think January 2015, she's referencing percentages of Oakwood revenue that were due to Mr. Parks. That's more than 2 years later. So and now Carter's involved. The Carter's developer fees need to be subject to this injunction because of what we witnessed time and time again today. There's so many different pockets. There's so many different entities. There's so many, they can't quantify how the deal is put together. They can't tell us which entities are subject to receive these developer fees, which entities are involved in certain aspects of the development. So let's look at what happened heading up to Exhibit 5, which has been the subject of a whole lot of what we've discussed today. It was quite clear that Mr. Parks was heavily involved in this deal. In fact, Mr. Taylor negotiated directly with Mr. Parks on the LOI, and just Mr. Parks on the LOI. And then when it's time to close the deal, they force an agreement that he won't be involved going forward. And why? Style, culture. They didn't like his style. He wasn't a culture fit. Well, you just can't push people out of deals because you don't like them, because you don't feel like their style is what it should be. Their culture is what it is not what it should be. Shockingly, Mr. Taylor admitted why he pushed him out. He kept asking for a larger percentage of minority participation in the deal. He admitted that today. That's what motivated him to push Mr. Parks out of this deal and require his business partner in a company that they don't have any interest in, and a company that they have admitted they have no dealings with internal operations. She signed a document saying that she would breach her fiduciary duties against her partner. It's amazing. I don't know if I've ever seen anything like that. And so after having admitted that Mr. Parks was pushed out of the agreement because he was asking about minority participation, then he was asking and then his culture and his style wasn't a fit. They go back 2 years later and they reduce Ms. King from 10 to 5%. They haven't passed that 5% back out to any minority participating companies. But here today, they lead with what this project means to the neighborhood. They want to talk about all the people who have been so disserved over the years in the neighborhood. Well, the people that they're talking about are not style and culture fit for what Carter is doing. Those are the same people in that neighborhood. And they don't get to use those people as pawns in their arguments to the court when they're cutting the knees out of people who are from those neighborhoods, who are from Atlanta, like Mr. Parks. They don't get to do that. They don't get to use what's beneficial to the minority community when it's beneficial to them. When they've cut Mr. Parks out of this deal, and then they've raked another 5%, and I guarantee you the 300K, I can't wait for discovery in this case, Judge, because I can guarantee you that 300K is not even closely reflective of the overall value of that 5%. But they got it back from Ms. King for $300,000. I bet you'll far exceed that number if you're just looking at that Publix deal and the land. That I think I saw that's 50 million plus on the Publix deal. And they've taken that back. So here's where we are, Judge. On the likelihood of success on the merits, we'll rest on our papers. I think we've covered everything to the extent the court would like us to address anything on the likelihood of the merits, success on the merits, we're happy to do so. Quick note on the timing of the motion. Ms. King abruptly terminated the New Columbia deal in September of 19. That's when we sent the demand letter over to New Columbia. That case was brought shortly after that time in the end of 19, resolved in July 2020. Of course, there was a pandemic in the middle of this, that slowed a lot of things down. So by the time we recognized what Ms. King was doing in terminating these contracts and frustrating Mr. Parks' efforts to enjoy the benefits of his interests, we actively started pursuing his rights. And we did so in a timely manner, given what was going on, pandemic-wise and otherwise. The irreparable injury. I think that's key here, Judge. What we have here are two instances where Ms. King has been a part of an agreement that frustrated Mr. Parks' entitlement to revenues associated with his company. We've got the New Columbia deal, the termination agreement, and that's part of our papers, where after we made the demand, after Ms. King agreed to pay Mr. Parks, or at least cede the money over to Mr. Parks, she went back behind him, entered into an agreement with New Columbia. And New Columbia then used that agreement to say, well, you're not entitled to any money. And then, this is critical, Judge, New Columbia said, we tried to get Oakwood to take the money. So if we have an adequate remedy at law, how do we go after her when she's not even taking the money for the company? So there's that. And then the second agreement, which is Exhibit 5. It's a documented conspiracy to push Mr. Parks out of the company. And she affirms that she will do so in direct violation of her fiduciary duties to Mr. Parks. So if you look at Exhibits E, F, and G to our motion for preliminary injunction, details quite specifically what we're talking about. And then, of course, Exhibit 5 here is Exhibit C to Carter's verified answer. Each time, those documents, those agreements that Ms. King entered into have been used in litigation to argue that Mr. Parks has no interest in Oakwood. So let's look at the labyrinth of entities that we've heard of today. We've heard of Oakwood, Summerhill, Cal. We've heard all of these other entities, all of these entities. And the CEO, I'm sorry, the president of the company can't tell you exactly how they fit together. He can't tell you where the money is coming in. We do have an affidavit that talks about some of that, right? But I think the best thing to do here, Judge, if I might suggest, is that the court consider establishing an escrow account where the Turner Field project developer fees must be deposited. And of course, plaintiffs are sensitive to the progress of the project. Our position is we have an equity stake in that project, so we don't want to do anything to hurt it, of course. So what we would propose is that the parties on both sides identify a neutral who would ensure that proper expenses on a monthly basis are backed out of the deposits or whenever they're deposited into, whether it's quarterly, monthly, or whatever the case may be. Expenses necessary, reasonable and necessary expenses for the project to continue can be backed out. For the neutral to oversee this process, each side can object to the neutral's decision as to what's reasonable or not. If there's a certain deposit, plaintiffs may object to the neutral as to, there has to be some disclosure of documents and source docs supporting the deposit. If there are any disputes, the neutral will decide, and if the neutral decides in a way that one party has a problem with, we can appeal to the court. What's the benefit of this, Judge? It keeps it out of your hair. It also puts it in the hands of someone who is knowledgeable in the space, someone with commercial real estate background, and that way we ensure that this is what it should be. I've done this in other cases. It worked quite well. I did it in front of Judge Westmoreland when I was on the other side of this case. And because we are sensitive and we don't want to hurt the neighborhood, we don't want to hurt the project, we don't want to hurt anybody. We just want what's fair, and we want what's ours, and that's it. Finally, what's in the public interest, Judge? I think it goes without saying that the public has a vested interest in ensuring that a company like Carter is going to parade around and show its DBE participants and talk about all the good that it's doing in the neighborhood, that it back it up in the boardroom where it really counts on a real impactful level. I mean, you're going to see, as this case goes on, you're going to see documents from Mr. Parks where he's trying to get monies that are due and owed to him for the efforts he's put in because he has to pay his kids' tuition. That's the real effect as well. I mean, Mr. Parks isn't some ogre in the woods. They haven't shown one document here today to support this misconduct, this disorderly conduct, this failure to be a culture and style fit. So that's the other thing that has to be considered. The public interest is just not passing out piecemeal bits here and there to folks in the neighborhood. It's doing the right thing on all fronts, doing the right thing with Black business owners like Mr. Parks and not excluding them from companies that were started for the benefit of his family.
Let me ask you a few questions. What is the evidence that you presented that shows that that he has an interest in Oakwood? What is that evidence?
Oakwood Development Group.
Whatever it is that you're claiming an interest in, what is the evidence?
Well, we'll start with the executed operating agreement, which shows that he's 49% owner. And that's attached to the second amendment, or first amendment complaint and the second amendment complaint. And then we've got the course of conduct of the parties. Ms. King represented on numerous occasions that Mr. Parks was her partner in Oakwood. And in many respects, she sought his approval. She understood that it was his company. And as Scott Taylor suggested, they go 51-49, where Ms. King could be a double minority as majority owner of the company. And I think they benefited from that greatly. And Mr. Parks took on that role at Mr. Taylor's suggestion, right? And then if you move that on down the line, now Mr. Parks is dealing with Mr. Taylor saying that he's not involved in the company at all. But it's to answer your question, it's the operating agreement, course of conduct of the parties, representations made to Ms. King, to other folks. And then if you look all the way through 2017, Ms. King is talking about percentages due to Mr. Parks. And she admitted she never paid any of those percentages due from that August 2017 email.
And what is the value of that interest?
That's a great question, Judge. We do not know. Certainly will be the focus of discovery. I don't think anyone here has been able to articulate what the value is at this early stage in the case. I can say that I strongly believe that 5% that she sold back to Carter for $300K is a gross underestimate of the value of that interest. And I think it's interesting that they got her to sell it back for $300K.
If I were to impose a remedy that you suggest, what sort of security could you provide for that expense in the event that you're not successful in the case? And whatever else is caused, whatever harm the defendants may suffer because of the delay of having their fees, what sort of security can you provide there?
Yeah, I haven't had that direct conversation as to a specific amount, but what I can say is the suggested format with the neutral, and I'll say again, Judge, that's designed to take a lot of the burden off of you and having to deal with such a structure. But that is aimed at ensuring that the project is not derailed, that they do not suffer.
I'm not talking about what it provides as a practical matter. I'm talking about in the event that you don't prevail in the case, your client doesn't prevail. Well, how does he reimburse the people who are entitled to those fees for the expense of having those things in escrow, whatever that may be?
So you're speaking of a bond, so to speak?
I'm speaking about what kind of collateral security, what are you going to put up?
Yeah, I can certainly have that conversation with my client and see what we can come up with, Judge. You know, he's certainly trying to ensure that these complicated corporate structures and folks who are actually entering into agreements to frustrate his ability to enjoy his equity in the company don't result in him being unable to find any assets. Or we've heard it here today. I mean, it's almost like whack-a-mole with the companies. No one knows where the fees are coming into and no one knows where they're going. So, but I can have the conversation with Mr. Parks as to what he would be able to come up with. And, you know, I don't pretend to know the financial wherewithal of Mr. Parks, but I would certainly talk with him and we would do our level best to come up with something that the court would deem acceptable.
You don't have anything today, is what you're saying.
I don't have anything today, but I can, if you tell me I need to go get something, Judge.
Well, you needed to have it today. You don't need it tomorrow. You need it today.
Okay, well, lay the number on me, Judge, and I'll go to work.
All right, let me hear from, you're done? Yeah?
I am done, Judge. Thank you.
Okay, let me hear from the defense.
Your Honor, if I may, I have a PowerPoint presentation that I'd like to show. I hope it'll help speed us along. If I can do screen sharing.
Okay.
Is everyone able to see? So, Your Honor, we're here today on a request for a preliminary injunction, which is a high standard. I first want to address the topic of the defendants who are here today and the defendants who are not here today, because I think that's an important distinction. We represent Kelly King, CL, and Oakwood Development Group, LLC. None of the other parties that plaintiffs attempted to add to this case via their second amended complaint that was filed last night. Those entities aren't here, and they would be harmed by an injunction if it was granted. Now, that's not to say that these other entities are secret or that they can't be found or that they can't be traced, but we want to point out at the outset that there are a lot of parties to the Turner Field deal. Healy Weatherholtz, for example, those parties aren't in court today and haven't been able to have their say. As for Ms. King, Seau, and Oakwood Development Group, LLC, let's turn to their role in the Turner Field project. As you know, I won't belabor this point. The materials related to the Turner Field project that are publicly facing have always stated that Kelly King is the 100% owner of Oakwood Development Group. I've highlighted that here. This comes from Exhibit A to Carter's response to plaintiff's preliminary injunction motion. And as Mr. Carter described, as my client described, Mr. Taylor, excuse me, a consortium of LLCs, which is controlled by Carter, owns and manages the Turner Field project. Oakwood Summerhill LLC is a member of the Turner Field project, to be completely clear. Oakwood Development Group LLC, the party that's being sued in this case and the party that plaintiffs claim an ownership interest in, it is not a party to any of the Turner Field JV agreements. Ms. King is the sole member of Oakwood Summerhill LLC. Distributions from the Turner Field project go to Oakwood Summerhill LLC. Those distributions do not flow to Oakwood Development Group LLC. Now, the plaintiffs are asking the court for emergency relief, as the court is aware. They are asking the court, and I think it's important to focus specifically on the requests that the plaintiffs made in their brief. They're asking the court to prevent the defendants from transferring any developer fees or any other revenues derived from the Turner Field project from defendants' bank accounts, requiring that all such funds be held in escrow. They're also asking that the court prevent the defendants from selling or conveying any land, property, or parcels in which Oakwood and Carter or any entities affiliated therewith hold a joint interest. And then they're asking for the extremely broad request of preventing defendants from taking any actions whatsoever that could in any way harm or be adverse to the interests of plaintiffs. But taking those first two in turn, first, it's immediately obvious from all of the testimony in this case and the testimony that we've heard today that this is a case about money. This is a case about developer fees. This is a case about revenues. This is a case about distributions. All of this boils down to money and fees. And even when it comes to the sale of any property that may be contemplated, those sales are simply going to result in monies that flow into, in my client's case, an Oakwood Summerhill entity, not Oakwood Development Group, LLC. I also want to point out that the standard here is extremely high. And something that we haven't discussed today is the fact that a preliminary injunction is meant to maintain the status quo of the parties pending a final adjudication in this case. A lot of the testimony today has gone to the merits of plaintiffs' claims. And we're really talking about whether Mr. Parks might ultimately prevail on his argument that he's an owner in Oakwood Development Group, LLC. But none of that evidence is relevant to whether an injunction is needed to maintain the status quo today. We haven't heard any testimony, as far as I'm aware, of what facts exist that entitle Mr. Parks or BPJ Enterprises to clear an urgent need for relief. The testimony that we've heard today involves facts that took place years ago. And the injunction that Mr. Parks and his company seeks would do anything but maintain the status quo amongst the parties, including parties that aren't represented here today. So we've discussed the four factors. I won't read this slide to the court. This is in our brief. But the most important factor, as the cases have held, is substantial threat of irreparable injury. I think Veterans Parkway case is instructive on this point. Equity will not step in where there is an adequate and complete remedy at law. That Veterans Parkway case involved a dispute over land. It involved some imminent construction. It arguably had facts that were much more urgent than any of the facts that we've heard here today. And the Supreme Court of Georgia overturned the trial court's grant of a preliminary injunction, finding that monetary damages would be sufficient to compensate the plaintiffs if there were any violations of law that were found. That's exactly the case that we find ourselves in today. As I've stated, all of this case is about money. It's about fees. It's about revenue from the Turner Field project. It is not a secret who the participants in this project are. We can trace the funds if that ever needed to take place. And at the end of the day, if Mr. Parks were to win on his claims, he would recover money, nothing else. We also pointed out in our brief that Mr. Parks's argument to membership in an LLC, Oakwood Development Group LLC, does not mean that he is automatically entitled somehow to a preliminary injunction to prevent the sale of property that's owned by that LLC. So OCGA 1411-501A provides that a member has no interest in specific limited liability company property. And we cited cases in our brief showing that even where the property of an LLC is at issue, a member of the LLC doesn't have an ownership interest in that property sufficient to entitle it to obtain injunctive relief. So the facts here are even more remote. We wholly dispute that plaintiffs are a member of Oakwood Development Group LLC. But even if plaintiffs were members of Oakwood Development Group LLC, and even if Oakwood Development Group LLC owned property in the Turner Field project, which it does not, plaintiffs would not be entitled to injunctive relief. Now, turning to the actual facts here, just thinking about this case from a practical standpoint, the testimony is clear that none of the Oakwood or King defendants that are in this case have any ability to actually control transfers of real property in connection with the Turner Field project. They hold a minority stake. They hold a 5% interest. And so even if Mr. Parks and his company had a membership interest in the appropriate LLC that was involved in the Turner Field project, which he clearly does not, such a membership interest would not give the plaintiffs any right to control any sales of transfers of property. The ownership interest that is at issue here only entitles the Oakwood defendants to a monetary distribution. It doesn't give them decision-making authority. They don't have the ability to control or in any way affect the transfers of property that are going to take place in connection with the Turner Field project. So, and my point there to put a pin on it is that even if Mr. Parks is able to prevail on his claims, ultimately, it doesn't change the outcome here, and it doesn't show that he's entitled to any injunctive relief whatsoever. I also just want to point out just how stale these allegations are. The amended complaint describes events from 2015 and 2016. We saw a lot of emails today from 2015 and 2016. That's when Mr. Parks's complaint arose. That's when he knew that the defendants in this case were not going to be involved with him moving forward in the Turner Field project. He didn't complain at that time. He didn't seek a preliminary injunction at that time. He waited years later. In 2017, that's when the wire transfer occurred to fund Oakwood Summerhill's involvement in the Turner Field project. That happened years and years and years ago, and Mr. Parks has never complained until now. In fact, the most recent allegation in plaintiff's motion for a preliminary injunction comes from November 1st, 2019, over a year before the motion was filed. And it's also notable that this letter, I'm looking at Exhibit E to plaintiff's preliminary injunction motion. This is correspondence between counsel, Mr. Miller, and an attorney at Hunter McLean. It's discussing Mr. Parks's purported ownership interest or lack thereof in Oakwood Development Group. It's the exact same thing we're arguing about today. Nowhere in this letter is an executed ownership agreement attached. And in none of the evidence that we've seen so far in this case, have we ever seen a fully executed copy of an Oakwood Development Group LLC ownership agreement that grants an interest to Mr. Parks or his company. You would think that if Mr. Parks's attorney was arguing about that ownership interest and trying to prove entitlement to funds back in 2019, he would have provided that evidence, but he didn't. In a lot of preliminary injunction cases, the harm to the parties or the harm to the public is not necessarily as clear as it is here. We found it very telling that plaintiffs allege in their motion, they argue in their motion, that as part owners of Oakwood, they are seeking to protect Oakwood and their interest in Oakwood. This preliminary injunction request does anything but protect Oakwood. It would attempt to place the Turnerfield project entirely on hold, only on the basis of speculative monetary harm to the plaintiffs who have not proven that they hold any ownership interest in any entity that participates in the Turnerfield project. The harm to the public is also an important factor. You've heard testimony today from my client about the impact of this project. I think it's probably apparent to all of us who are present today that this is an important project for the city of Atlanta. Oakwood is a minority-owned, disadvantaged business enterprise that is participating in a project of major significance. The residents around the Turnerfield project, businesses that trickle down all across the region, would be affected if this project is put on hold. And that's exactly what this injunction is designed to do, despite council's comments earlier. So again, this preliminary injunction would do anything but maintain the status quo. And for that reason, the request should be denied. Now, I think we've argued in our brief, and I don't want to, in the interest of time, belabor the likelihood of success on the merits argument. But it's important to point out plaintiffs' claims largely, if not wholly, depend on proof of an ownership interest in Oakwood Development Group LLC. And going to the court's question earlier about proof of that ownership interest, I'll quickly go through these slides. When plaintiff filed his initial verified complaint, he attached as Exhibit A as his proof that there was an ownership agreement that granted him an ownership interest in Oakwood Development Group LLC. He attached these two signature pages that appeared to only be executed by Kelly King. They were not executed by his client. Then, when he filed Exhibit A to the amended verified complaint, suddenly we see a January 2nd, 2015 email from Ms. King to Brandon Williams, the attorney at Austin & Byrd, who put the documents together, that purports to attach a signature block for the operating agreement that is now executed by Mr. Parks with Ms. King's signature. And to us, this doesn't make any sense because on January 2nd, 2015, Mr. Williams had circulated a version of the ownership agreement that, and I'm gonna flip around here. On January 2nd, 2015, Oakwood's attorney circulated an execution version of the Oakwood Development Group LLC operating agreement to Ms. King, copying Bernard Parks. This execution version granted 100% ownership to CL LLC. Yet somehow, according to plaintiffs, a version of the operating agreement that was circulated on September 12th, 2014, that would have granted BPJ Enterprises a 49% share was then signed in January of 2015. The timing doesn't make any sense to us. We think this signature block is suspicious. And so we wholly intend to contest in discovery that Mr. Parks has any ownership interest in Oakwood Development Group LLC. So in sum, even if he were to prevail on that claim, that would not entitle him to an injunctive relief in this case. Mr. Parks has no legal connection to the Turner Field project. He hasn't made a showing that he will suffer any non-monetary harm, and he hasn't given the court and the parties a reason to upset the status quo and harm the public. And I would also point out, we addressed the issue of the bond in our briefing, but having heard argument of counsel today, it's extremely concerning to our clients, of course, that a bond would need to be put up to protect us if an injunction were granted. And I think that's an important consideration for the court to make. So with that, I will ask that the court deny plaintiff's motion for preliminary injunction.
Very good. Thank you.
Just very briefly, if I might make one point as to the irreparable injury.
All right, that's one point.
That's one point. There was a point that Miss, is it Mitchell? I'm sorry, it's Megan Mitchell, right? It's Mitchell. Yeah, that she made about,
Yes.
about protecting Oakwood. We've heard the testimony about 5% of Oakwood's interest being sold back to Carter at $300,000, which is apparently a ridiculously low amount of money. Miss King is the one that Carter wanted at the helm of Oakwood, not Mr. Parks, because they knew Mr. Parks was going to insist on appropriate participation in the deal. They'd gotten who they wanted. Mr. Taylor admitted that he pushed Mr. Parks out. So because he kept asking for additional percentages, what he felt was fair for minority participants. So my point here, Judge, they've got who they want at the helm of the company, and she's running the company in the ground. She gave up 5% of their interest in the entire deal for $300,000. 49% of that 5% was Mr. Parks. That was Mr. Parks, and she sold it for $300,000. So if you leave the status quo, if you don't preserve the status quo, she's going to continue to run this company in the ground, and there's no way we can get the value back if she continues doing what she's doing and she continues to be taken advantage of by Carter.
Very good. Thank you. All right, we'll get an order out to you all shortly.
Whoa. Can I close, Your Honor?
Yeah, I'm sorry. Go ahead.
Thank you. I will spare you my PowerPoint that I had prepared, but you're being asked to do equity. And a claimant that asked to do equity must do equity. And here, there are several failings in this plaintiff in terms of its ability to ask for equitable relief. First of all, it has the wrong entities. And despite the fact that they suggest that we only raise that in a footnote, we raise that in the 16th and 17th defenses of our answer. Second, they never even asked us or even asked for any efforts to try to figure out who it was. We voluntarily submitted an affidavit. And while we haven't taken the court's time to go through that affidavit, it describes clearly who the appropriate entities are, as well as where the funds flow. Third, Mr. Parks does not appear to be someone who has clean hands. After listening to the shocking testimony of Ms. King as to the behavior that she suffered through, it is hard to believe that Mr. Parks fits the definition of clean hands. And finally, surprise. When I say surprise, we started asking for a preliminary injunction and we ended up asking for a receiver. If in fact the remedy that is being sought here today is receiver, that I argue surprise, and we've not had an opportunity to brief the appropriateness of that in this context, and it is premature and improper in this context. Now, what did they ask for? They asked for an injunction that was so overbroad that it caused irreparable harm to innocent people not in this litigation. And it is essentially a prejudgment attachment. And I'll talk about that more later. And who are these people? They are the Summerhill community who need that Publix grocery store. It's the city and its development efforts to restore this undervalued, massive tract in its heart, the private funders who are uncomfortable with shenanigans like this going on, the GS students who need the housing, and the private renters who possibly need the facilities. Mr. Parks is a false champion of minority partners. Ms. King's organization fits the definition of what a minority partner is. And in fact, in some realms, they consider a female and a Black owner as being double credit. So this is a false championship that's being proposed here. The injunction itself, when originally in the motion at pages 16 and 17, were overbroad and have changed under our feet here. Mr. DeBose pounded the merits, but did not talk about the 4 elements necessary to prove the entitlement or the right to, or privilege more likely, to an injunction. There's no urgent need for extraordinary relief. There is an adequate remedy law. It is his allegations and proof of irreparable harm are speculative, and there's no real interest in this property held by this plaintiff. It's also important to understand that there's no decision-making authority vested in Oakwood or any of the Oakwood successor entities. All the control and decision-making in these entities is controlled by Carter, and thus the only thing they can hope to recover is monetary damages. Factor number 2, have the plaintiffs shown that their threatened injury outweighs the harm to Carter? This is a $500 million project. They speculate at best that $300,000 is an undervaluation of 5%. Okay, say it is, in their view, is worth $1 million. $1 million of potential monetary value to them versus the stopping a $500 million project in its tracks. That is not showing that they've outweighed the harm to Carter and the city and the other participants in this project. Is there a substantial likelihood of success? No. There's been a lot of effort pointed to the letter of December 30th, 2015. You need to read it carefully. It is one of those carefully drafted lawyer letters. It does not say that that Mr. Parks has no interest in Oakwood Development Group, Inc. It says instead different entities are questioned as to what is the association. He was not kicked out of that partnership by Carter. If he was kicked out of that company, he was kicked out by Kelly King, not by Carter. Does this serve the public interest? No. Last but not least, we keep hearing what I call the whack-a-mole argument. That is, oh my gosh, this is so difficult to determine who the real entity is if the court feels relief is appropriate. Again, like I said, in the Stringer affidavit, it's all laid out. But what they're really doing is seeking a prejudgment attachment and suggesting that somehow we're going to be unavailable or leave the state or abscond or conceal ourselves. None of that predicate is here, but even if they met it, they're required to post a bond equal to 2 times the potential claim. If you take it what they say is true, Mr. DeBose just said that $300,000 was a ridiculously low sum of money, then say the number he really thinks it's worth is $1 million, he needs to post a $2 million bond. Same result under Rule 65. A prerequisite to the issuance of restraining order, the court may require the giving of security by the applicant in such amount as the court deems proper for the payment of such costs and damages. And we would contend that that would be a payment of at least $2 million. Thank you for your patience, Your Honor. I didn't mean to keep you extra long.
Judge, I hate to say it, but one thing about the parties, we did file our second amended complaint. We named all of the parties that we could take from the affidavit. We did our level best to try to get the right parties at the table. The summons are going out. They'll be served. To the extent there's any question, might we propose a short 30B6 to sort all of this out, because there's really no way to figure it out outside of what they provided. We're not asking for a receiver. We're not. That's not what the neutral is. He's not going to take over the project. He's not going to be able to run the affairs of the project. And that's all I have to say.
Thank you.
We are done now. Yes.
I am done, Jeff. Thank you again.
No, thank you. You all made a fine presentation, but we will have that order